Morning, Chair and co-commissioners. Apologies for forgetting to honor the standing arrangement.
No problem.
Chair, before we start with the witness, and for purposes of locating her evidence within the terms of reference, might I ask perhaps to first, by way of outline, touch briefly on some of the terms of reference. We know that in terms of the terms of reference, the Commission shall inquire into, report on, and make findings and recommendations concerning. Then I'm reading from 1, and I'm going to read 1.1 of the terms of reference. Whether criminal syndicates, including but not limited to drug cartels, have infiltrated or exert undue influence over the South African Police Service, including the Political Killings Task Team and Crime Intelligence. Then I skip to the second term of reference, and there I'm going to read read with 2.2. The nature, extent, and consequences of such infiltration or influence, including the suppression or manipulation of investigations. Then 5 and 6, the effectiveness or failure of oversight mechanisms and the adequacy of current legislation, policies, and institutional arrangements in preventing such infiltration.
The latter being 6.
Yes. Thank you, Chair. And the next witness, Major General Van Rooyen, is going to testify in respect of the legislative prescripts and in an endeavor to assist the Commission in answering part of those questions.
May I immediately tender an apology, General? I addressed you as Ms. Apologies.
No.
Absolutely no need to apologize, Chair.
Thank you. General Mukwanezi told us that regardless of what comes before the General, whether Major General, Lieutenant General, the mode of address is General. Thank you, General.
Thank you. I hope by the end of the hearing, I'll also be referred to as General Motau. Ma'am, if I can then perhaps also, before we start with the questions, Chair, I appear together with my learned friend, Advocate Lee Segal Ngube, and I should also acknowledge one of the team members who was crucial in the preparation of this aspect of the work, who was unable to be with us this morning, Advocate Ufenze Mutlasedi. Thank you. So the engine room did its part, I should do mine. General, in front of you there are 2 files. There's one smaller file, which is file 1, and there's one bigger file, which is file 2. And Chair and co-commissioners, I don't know whether for purposes of the record, do we follow that sequence? Is it Van Rooyen 1 and Van Rooyen 2?
Yes, please.
Thank you, as the Commission pleases. If I can ask you to go to file 1, Van Rooyen 1. Do you confirm that that is your statement? And if you turn to page 46 thereof, is that your signature that appears on that page?
That is correct, sir.
Thank you. Then if I can ask you to turn back to paragraph 1. You state that you are a Major General in the South African Police Service and that you hold a doctorate degree in law. Is that correct?
That is correct, sir.
How long have you been with SAPS?
Close to 42 years of service.
Purely out of interest, doctorates in law may be a PhD, which I've seen mostly with Rhodes University. Most usually have LLDs. So it may be a PhD or an LLD. What is yours?
Chair, I've got an LLD.
Thank you.
For reasons that we won't go into, the chair's knowledge in this area is something we don't need to dwell into. And also the choice of the institution that is referred to.
Mr. Matau, my interest is in what field, specific field of law is the LLD?
Criminal law, sir.
Thank you, Chair and co-commissioners. General, in paragraph 4...
Sorry, if I may just add, I've got a master's, the LLM in constitutional law or fundamental rights and constitutional practice. Just for the record, while we're sharing secrets.
Thank you, General. In paragraph 4, you deal with the co-functions of the position that you occupy. If I can just ask you to take the Commission through those.
My core functions as the head of governance, legislation and policy, that is in the Division Legal Services, is to oversee the governance, legislation and policy service within the police. It involves the management of legislative and regulatory functions, to ensure the legal vetting of new and revised policies in the police, and to provide legal support on advocacy functions, as well as to manage and utilize human, financial, physical and information resources in accordance with the strategies, priorities and regulatory framework of the police.
What exactly do you mean by vetting policies?
Chair, that would be, for example, if there's new national instructions relating to an operational or a support function, the policy owner, for example, visible policing, will be the compiler of the document, the national instruction, and then it is forwarded to us for legal vetting to ensure that it complies with the law, that it's not in conflict with any other prescript in the police, and to also make a recommendation for the National Commissioner on the approval thereof.
General, what is advocacy functions for the SAPS?
Commissioner, that relates specifically to new developments in law, court judgments and the implications thereof on the police, and specifically relating to judgments and where we can improve our regulatory framework.
And just before you go to the next section, General, who do you report to?
I report to the Divisional Commissioner Legal Services, and we are part of the support services, the Deputy National Commissioner. In other words, that would be either General Nkwa or General Tampane, and thereafter the National Commissioner.
Thank you. In paragraph 5, you state that you made the statement for purposes of giving evidence at the Commission, and it is at the invitation of the Commission. Is that correct?
That is correct.
And then in paragraph 6, you outline the themes that your statement covers or deals with. And it is clear from there, you firstly highlight the constitutional and statutory framework regulating SAPS. You provide a legal overview of the applicable legislation and policies regulating the SAPS. You also provide a detailed analysis of oversight mechanisms that regulate SAPS. you proceed to then deal with the disbandment of the PKTT by the minister, and you provide your view on whether the conduct accords with the statutory framework set out in your statement, and you conclude by making some general observations on legal aspects that have been raised and identify potential deficiencies in respect of the oversight mechanisms. Is that correct?
That is correct, sir.
Yes. Then if I can ask you to deal with the first topic, which is SAPS constitutional and statutory overview. You deal with that commencing from paragraph 7. Yes, if I can ask you to deal with that.
Okay. In this section, I explained that the workings of the police with reference to the relevant portions of a constitution and legislation and regulation of a service. Section 199 of the Constitution regulates the establishment, structuring and conduct of a security services, a single defence force, a single police service and any intelligence established in terms of a constitution.
Have you not left out services after intelligence, or am I wrong?
I believe that's a typing error,
No,
Chair.
right.
You are correct, yes.
Thank you.
All of these services are structured and regulated in terms of national legislation. Section 199(6) of the Constitution provides that no member of a security services may obey a manifestly illegal order. In terms of Section 199(7) of the Constitution, members of any security service must always act in accordance with the Constitution and the law, and may not act to either prejudice a political party's interest that is legitimate in terms of a constitution, or further, in a partisan manner, any interest of a political party. Section 189,
Sorry, section 198.
Sets out the governing principles.
Before you move on, let's go back to 8, section 1996. Who does that relate to? Ordinarily, one would think that it relates to orders from a member of SAPS, a senior member to a junior member. Does it go beyond that or not?
Chair, it's my submission that it relates to any member, irrespective of where the order comes from. But if it is in the execution of his powers as a police official, it will mean that he cannot obey a manifestly illegal order.
Oh, thank you. What I wanted to, or rather what I want to understand, is whether this would go beyond SAPS. For example, an order / instruction from outside of SAPS. I'm not pushing you to say yes. I just want to understand your interpretation of the section. Does it relate? Is it an intra-SAPS provision?
My understanding or my interpretation will be, if the person is to exercise a policing power, then it means he cannot exercise, irrespective of whether that instruction comes from a commander or whether it comes from anybody else who is capable of giving orders to that member.
So I think perhaps just to be clear, your response is it is not necessarily applicable only intra-SAPS.
That's correct.
But it would apply even if an instruction emanates from outside.
Yes.
But it is expected to be executed by a SAPS official as a member of the service, as contemplated in section 1996.
Yes.
Okay. Thanks. Then if you can proceed in paragraph 9, you deal with section 198.
Section 198 sets out the governing principles of national security. The police as a national security entity must reflect the resolve of South Africans to live as equals in peace and harmony, free from fear or want. Must pursue national security in compliance with the law, including international law. and must remain subject to the authority of Parliament and the National Executive.
Okay. Then your next subtopic is the constitutional mandate of SAPS, which you cover from paragraphs 10 to 17. If I can just ask you to please deal with those. Commencing from paragraph 10.
Okay. Section 205 to 208 of the Constitution sets out the constitutional mandate of the police, the control of the police, and assign political responsibility of the police service. Section 205(3) starts off with the objects of the service, and it relates specifically to prevent, combat, and investigate crime, to maintain public order, to protect and secure the inhabitants of a country and their property, and to uphold and enforce the law.
Yes.
205(2).
Sorry, before that, we know that this section you deal with it later, but it is going to be important on the aspects that you deal with in relation to the minister's instruction or directive that he issued on the 31st of December 2024. Is that correct?
That is correct.
Okay. All right, we'll deal with that when we get to that section of your statement. If you can proceed with 11.2.
National legislation must establish the powers and functions of the police service and must enable the police service to discharge its responsibilities effectively, taking into account the requirement of the provinces. The SAPS must be structured to function at national, provincial, and where appropriate local spheres of government. In terms of Section 206 of the Constitution, the Minister of Police must determine national policing policy. This he does after consulting all the provincial governments and taking into account the provincial needs and priorities of the provinces as determined by their respective executives. Section 206(2) provides that the national policing policy may make provision for different policies in respect of different provinces, after taking into account the policing needs and priorities of the respective provinces. Each province is entitled to monitor police conduct within its area of jurisdiction, oversee the effectiveness of visible policing, and liaise with the minister in respect to crime and policing of the provinces. Section 206(8) of the Constitution prescribes that a committee made up of a Minister of Police and members of the executive councils responsible for policing must be established to ensure effective coordination of the police service and effective cooperation amongst the different spheres of government. This committee is commonly referred to as MINMEC, meaning Minister of Police and MECs. The National Commissioner appointed by the President in terms of Section 207 exercises control over and manages the police service in accordance with the national policing policy and directions of the Minister of Police.
And again, if I can just indicate here, just to highlight where you are going, this is also going to be a relevant provision when you deal with that instruction.
That is correct.
Yes, if I can then ask you to proceed from paragraph 15.
Provincial commissioners are appointed by the National Commissioner with the concurrence of a provincial executive in terms of Section 207(3) of the Constitution. The provincial commissioners are responsible for policing within their respective provinces as prescribed by legislation and are subject to the power of control and management of the National Commissioner. The Intelligence Division of the Police is part of the National Intelligence Structures Act as determined, or as is part of the National Intelligence Structures as determined and governed by the National Strategic Intelligence Act.
Yes,
and maybe I can just pause here and indicate that in terms of the National Strategic Intelligence Act, there are specific powers assigned to the Commissioner, or the head of a division of crime intelligence. So there are certain operational powers that specific individual, which in this case is Lieutenant General Dumisani Kumalu, is empowered to exercise. The powers of crime intelligence of a police in respect of the National Strategic Intelligence Act relate specifically to the gathering and analysis of intelligence for the furtherance of the objects of a police as set out in Section 205(3), in other words, to prevent, combat and investigate crime, uphold and enforce the law. To furthermore take steps to address counterintelligence in the police. This also includes security vetting and security screening of police officials. That is a specific power assigned to the Division Crime Intelligence in terms of the National Strategic Intelligence Act. And then furthermore to report on the intelligence gathered by the police to NICOC. NICOC is the National Intelligence Coordinating Committee. Where all three intelligence services are represented. In other words, SSA, military intelligence of the defense, as well as crime intelligence of the police service.
Perhaps if I can just interrupt you there before you deal with the summary that you pulled together in paragraph 17. We know that the National Commissioner, as part of his evidence, dealt with the two requests that he defined as 3 areas of contestation where dockets that relate to intelligence were sought, or at least were requested to be transferred to Lieutenant General Sibia, and he told the Commission that first that request was made by General Sibia himself, and then later also when the minister took office, or at least some time thereafter, he also made a similar request. So this is a very important aspect in respect of areas that the Commission will have to determine as part of its terms of reference.
That's
Am I
correct,
correct?
sir.
Very?
Yes, that is correct.
That's correct. Right. And then you conclude in paragraph 17 by saying, in sum, the Constitution establishes a single police service. This concept creates one unified and standardized police service across the Republic under the leadership and command of the National Commissioner, and we know that this references Section 207(1) of the Constitution.
That is correct.
Then the next topic that you deal with is the South African Police Service Act, the SAPS Act, and you start from paragraph 18, and if I can ask you to commence from there.
The Police Act is the legislation contemplated in Section 199 of the Constitution that provides for national legislation must regulate the security services. In terms of a preamble of the Police Act, provision is made for the establishment, organisation, regulation and control of the police. It determines the terms of office of commissioners, the National Commissioner and Provincial Commissioners in Section 7, the recruitment and appointment procedures of members in Section 28. It also sets out the powers, duties and functions of respective functionaries and members in Sections 11 to 15. It provides for the authority to issue national instructions and orders in terms of Section 25. And it provides for disciplinary proceedings in terms of Section 40.
Okay. Then you next deal with the key SAPS role players. And the first key role player there is the Minister of Police. If I can ask you to proceed from paragraph 20, and just note the date there that needs to be corrected when you deal with that paragraph.
Mr. Senzo Mchunu was sworn in as the Minister of Police on the 3rd of July 2024. The typing error, the glaring typing error should be excused. And this is important because in terms of Section 95 of the Constitution, before a minister begins his tenure or begins to perform his functions, he must be sworn in. So that means once he's been sworn in, he is the Minister of Police. And it means that the term of office of Minister Mchunu started on the 3rd of July last year. He swears faithfulness to the Republic and obedience to the Constitution. On the 13th of July this year, Minister Nkunu was placed on leave of absence with immediate effect, and the President appointed Professor Feroz Kachalia as the Acting Minister of Police in terms of Section 91(3)(c) of the Constitution. The powers and functions of a Minister of Police in South Africa are primarily defined by the Constitution as discussed above and in terms of the Police Act. The Minister's role is to provide political oversight and to determine national policing policy, while operational control of a police service is vested in the National Commissioner. The Minister's key powers and functions involve the following. The Minister is responsible to formulate national policing policy in consultation with the provincial governments. This ensures an overall strategic direction of a police. This ensures that the overall strategic direction of a police service is aligned to national priorities in accordance with Section 206 of the Constitution. And in this regard, it should be noted that the Civilian Secretariat for Police Service has drafted various policy documents for approval by the Minister. It includes, for example, a policy on the reduction of barriers in the reporting of sexual offences and domestic violence. This policy aims, inter alia, to strengthen efforts to prevent and deter sexual offences and domestic violence by broadening and deepening the collection of information about such crimes and to increase the access of victims to justice by reducing barriers to the reporting of sexual offences and domestic violence. A policy, once approved by the Minister, will require the National Commissioner to take steps for implementation and operationalization. It should further be noted that the national policing policy, as envisaged in Section 207(2), was only approved in Parliament, in Cabinet in July of this year.
Now, can I ask you,
General, please pause there for a moment.
Okay.
The policies you refer to in paragraph 22.1, do you have sight of them before they go to the Minister for approval? What happens after the Civilian Secretariat has drafted those policies?
Part of the drafting process involves consultation. So even in the deliberations of a policy, the police will be roped in, so that we also deal with policing aspects, because it's no use to issue a policy that's not implementable and practical for the police service. So once the Civilian Secretariat has completed the draft document, it will be submitted to the Minister for his approval. Once it has been approved, it will be submitted to the National Commissioner with an official letter indicating that this has now been approved and the implementation plans should be drafted to ensure the effective implementation of the policy.
In the last sentence of paragraph 22.1, you indicate that it should be noted that the national policing policy was only approved by Cabinet in July 2025. Can I please ask you to indicate what was the position in respect of the national policing policy before that date? Was there one in existence?
No, this is the first national policing policy that was approved since the interception of the Constitution. There were strategies previously, for example, the crime prevention strategy of 1996, but this is the first national policing policy that was approved and is currently being implemented.
I suppose the Commission will hear more about the instruction that was then given on the 31st of December 2024 under the guise of a policy direction.
Yes. Chair, if I maybe can just, for the benefit of the Commission, just indicate that the national policing policy, the one that was approved in July, indicates 4 policy areas, and it's high-level areas. It relates, first of all, to effective policing. The second area, and there's a number of recommendations, but it just indicates the strategic level of a document. The second one relates to service delivery. The third one relates to community involvement and the need to have participation of a community in respect of matters relating to police. And the fourth one deals with ethical and strong leadership in the department. So those are the four pillars or policy areas specifically addressed in the national policing policy.
Yes.
What exactly does service delivery deal with or relate to?
There's a number of issues. For example, the treatment of complainants and the need to consider their privacy and to make sure that there's feedback given to a complainant once a case has been reported. It also deals with effectiveness in the gathering of evidence and the analysis of evidence during an investigation. So it basically deals with the delivery of policing services, whether it relates to crime prevention and our engagement with schools and other entities in respect of crime prevention, or whether it deals with the effectiveness of detectives and the manner in which investigations are conducted, including matters such as the analysis of forensic services, the DNA, the ballistics, and how the services in that regard can be addressed to ensure improvement and promotion of effective policing.
Thank you, Mr. Mtau. General, in the absence of national policing policy, which you say was approved by Cabinet only now in 2025, what has guided the police in the everyday operations or work that they do?
Keep in mind, Commissioner, that this relates specifically to the role of a minister. And certain policies, such as the one on the reporting of, or the removing of barriers in the reporting of domestic violence and sexual offences, was a policy. It was simply not the national police policy or policing policy. And there's been other policies as well as the white papers on safety and security and the white paper on policing that were approved in 2016. But apart from that, our internal directives relate to national instructions, circulars, SOPs that are approved by the National Commissioner, and in the case of SOPs by the relevant divisional commissioner, to ensure effective policing and also to address policing needs. But those are the internal policies of the police to deal with policing matters.
You said somewhere in your response that there were other policies as well. I hope I heard you correctly.
That is correct.
What were those other policies?
As I indicated, there was a crime prevention strategy of 1996. That was a strategy issued by the Minister of Police. There's other policies relating to the use of force by the Minister that was prepared by the Civilian Secretariat, and also policies relating to community policing structures. So they were policies, but relating specifically to a aspect or a topic. The national policing policy cuts across policing in a more general and generic manner.
The one about strategic something, what exactly was that one about?
Sorry, Chair, I didn't get the first part.
The title or name of one of those has strategic in it. So I'm asking what that one addressed or addresses.
It was the crime prevention strategy. So it wasn't called a policy, it was a strategy. But it related to policy and direction in respect of crime prevention matters.
And would that not relate to the area of function of the PKTT? Because sitting where I am, I consider that to have everything to do with crime prevention, or is it about detection only?
The PKTT is an operational unit dealing with the investigation of crime. So the ripple effect will be to prevent crime once a perpetrator has been arrested and weapons have been seized. In other words, to prevent the further commission of crime. But their primarily responsibility is to investigate and resolve crimes that have already been reported to the police.
Or perhaps more directly then, would this policy that you and I are discussing not be applicable at all to the area of function of the PKTT?
Not really, Chair. It relates more to what we can call uniform police officials. In other words, the frontline services of policing.
Thank you. Is it not best, I do not know how thick those documents are, but is it not best perhaps that we should have sight of these policies?
No problem. We can make it available to the evidence leader.
Thank you. Thank you.
General, if the crime prevention strategy, you say in 1996, now we've had evidence that crime over time, criminal conduct over time has taken different shapes. Now we are speaking of syndicates, now we are talking about illegal mining and different sorts of crimes. On the face of it, and unless you say over time since 1996, there's a revision of the strategy to deal with new things, new forms of criminal conduct. On the face of it, a 1996 strategy, if it remained that, it doesn't seem like it responds to new ways of crime. What mechanism has been in place or is in place to deal with the new manifestations of different forms of crime?
Commissioner, I agree.
What has brought us here, for example,
Yes,
we speak
yes.
about criminal syndicates.
Yes, I completely agree with you. If we consider the world that we lived in 1996 in comparison to 2025, very little has stayed the same, and the same applies in respect of crime. Crime is a ever-evolving scourge. And even the priorities, as you mentioned, illegal mining, even cyber crimes, were things that nobody contemplated in the era pre-2000. What we in the police are doing is there's numerous regulatory frameworks that we have. For example, national instructions, and national instructions will deal with general matters. For example, we have national instructions relating specifically to legislation, such as the domestic violence national instruction on children in conflict with the law to address the police's responsibilities in terms of the Child Justice Act, instructions on sexual offences dealing with the Criminal Law and Related Matters Amendment Act, and police procedures. So they are based on legislation, but it also addresses the internal processes. In other words, what official forms will be utilized? What are the time frames that we require police officials to attend to certain matters? What are the reporting mechanisms included in the police? Then apart from that, we've got national instructions on operational matters, such as case management. In other words, when a case is reported, what are the time frames? What happens to the docket when it's opened? How do you complete the docket? How do you update the system with events as they unfold in your investigation? In addition to that, we've got SOPs. For example, standing operating procedures are not issued by the National Commissioner. National instructions are. If I can just park SOPs for a moment, also what we have in the police is the Constitutional Court makes a ruling today that renders a specific provision relating to policing unconstitutional, which means there must be immediate action from the police's side to ensure that police officials take note and immediately implement the ruling of the court. On matters relating to cannabis, for example. So in that regard, there's no time for a national instruction because that's quite a comprehensive process. And we will deal with amendments in terms of court rulings by means of a circular. It's a shorter process. It's still approved by the National Commissioner, so it's an instruction from the National Commissioner, and every police official has to comply with that instruction. Then when we get to provincial commissioners, they can issue provincial orders and instructions specifically relating to their province, as long as it is not in contravention with a national instruction or an instruction by the National Commissioner. Then we've got SOPs. SOPs are more action steps. They can be supported or they can be in support of a national instruction dealing with more nitty-gritties on a specific aspect. For example, in visible policing, there's SOPs relating to firearms, the issuing of permits, dealing with firearms in deceased estates and things like that. That's supported by the Firearms Control Act. And then we also have in our operational structures, such as the NAT joints, operational instructions that can be issued. And specifically, in the NAT joints, we have priority committees. For example, a priority committee dealing with illegal mining. And that NAT joints will issue NAT joints instructions. And that is coordinated. The NAT joints is chaired by the Deputy National Commissioner responsible for policing, Lieutenant General Musikidi, and co-chaired by the SSA and the Defence. NAT joints instructions will be instructions that coordinate the operations between those departments. In other words, it's not only an instruction issued by the police for other departments, but it's signed by the co-chairs as well to ensure that it cuts across different departments to deal with specific aspects. For example, the illegal mining. Even during COVID, there were a number of NAT joints instructions issued to deal with COVID during that time. So there's different levels of instructions that may be issued, and it doesn't depend on the directives of the minister, because after all, the police has to operate continuously and deal with emerging threats and trends in policing, and we have to make a plan on how to deal with them.
Just for your comment, because further on you do deal with deficiencies and you will be making suggestions. The crime prevention strategy 1996, as you, from your experience and as you sit there, you consider it continues to remain adequate, or in the light of this just immediate past discussion that we've had now? Does it remain adequate and relevant? Is it something that does require revision, reconsideration? What's your comment on that? And I ask the question without having any insight into what that strategy is and, in fact, what it deals with.
Commissioner, it's definitely required to be updated in view of current policing threats and challenges. But I do believe that the national policing policy actually addresses a number of issues that should have been updated in the meantime. So in that regard, it's not a document that should be seen in isolation. It deals with directives and policies issued by the minister.
Thank you, Commissioner Baloyi. Proceeding to still deal with the minister's key powers and functions, if I can ask you to proceed from paragraph 22.2.
The minister is the cabinet member responsible for policing and oversees the Department of Police. The National Commissioner reports directly to the minister in terms of section 207 of the Constitution. The minister also has the authority to make regulations on a wide range of matters to ensure the proper implementation and administration of the Police Act. And this is provided for in section 24 of the Police Act. The minister has, for example, issued regulations on matters such as discipline, employment, municipal police service, and reservist, just to mention a few. In addition, several key entities report to the minister. Their functions are regulated by separate legislation, but the minister provides overall strategic direction and oversight. These departments and entities are as follows. The Civilian Secretariat for Police Service, they are responsible...
That's CSPS.
CSPS, yes.
Okay.
They conduct civilian oversight of the police and provides policy and strategic support to the minister. They are also responsible to give strategic advice to the minister in respect of the development and implementation of policies. It also monitors the performance and compliance of the police with policy directives and monitors the performance of the police service and regularly assess the extent to which the police service has adequate policies and effective systems, and they can make recommendations for corrective measures. The second department, apart from the Civilian Secretariat, is the Independent Police Investigative Directorate, commonly referred to as IPID. They are an independent body that investigates serious crime and misconduct committed by members of the police and municipal police service. The minister plays a role in the appointment and suspension of its leadership. So it's important, Chair, to take note that in the Ministry of Police, there are 3 departments: the South African Police Service, the Civilian Secretariat of Police, and the Independent Police Investigative Directorate. Separate departments, separate Director Generals, separate budgets. But in addition to the departments, there's also the entity reporting to the minister, and that is the Private Security Industry Regulatory Authority, CIRA. They are responsible to regulate private security industry under the minister's purview. Finally, in respect of cooperative governance at provincial level, the minister must consult with provincial governments when developing national policing policy to take into account the specific policing needs and priorities of each province. And as I've indicated earlier, the minister chairs the MINMEC committee that consists of the minister and the members of the executive councils responsible for policing. This committee facilitates cooperation and coordination between the national and provincial spheres of government.
All right, can I just ask you, as you are about to deal with paragraph 26, you start that paragraph in your first sentence by stating that the need for clarity on the role of the minister has repeatedly been raised as a concern. So as you deal with that paragraph, if I can just ask you to perhaps give examples where this issue has arisen, because you say it arose repeatedly. So if you can please proceed to deal with paragraph 26, bearing that request in mind.
The need to clarify the role of the minister has repeatedly been raised as a concern. It appears that there are different interpretations to words given or words contained in Section 207 of the Constitution that requires the National Commissioner to exercise control over and manage the police service in accordance with the national policing policy and the directions of the cabinet member responsible for policing. According to the Oxford Dictionary, policy refers to a course or principle of action adopted or proposed by government to achieve a particular goal, often outlined in written form or as a clear guideline for conduct. Chair, this relates specifically to the question whether the letter of the minister on the 31st of December 2024 was a direction given in terms of Section 207 and whether that fell within the purview of a minister to give that direction. So policy is clearly something that is proposed to further government goals, and it's often outlined in written form. And I believe in view of our discussion on the national policing policy, we all have a better idea of what it entails and also the strategic level of matters that are addressed in that policy as an indication of government's goals and aims.
But if I can just ask you to stop there perhaps. You recall the National Commissioner said he reached out to the President. The President said he'll talk to the Minister. And then in one of those meetings where this issue was discussed, the National Commissioner says the President is in agreement with the disbandment of
Yes.
the PKTT, and therefore, by extension, the President was in agreement with that instruction that was issued. Does that make any difference in relation to your definition as you've referred to as policy?
Government's policy does not only relate to the decision or view of a president and a minister, and this is even more pertinent in view of our current government of national unity. So it cannot be proposed that even if it was discussed with the president, it has now become government's policy or government's intention to dissolve the PKTT.
All right. I understand your answer. Please proceed. This appears.
This appears to be aligned to the requirement that the national policing policy requires consultation with provinces to ensure a course of action to achieve a particular goal, in this case to address policing needs and priorities. This is furthermore consistent with the policies already drafted and issued by the Minister of Police, which were written documents and aligned to government priorities, with the aim to provide medium to long-term strategic course of action. In contrast, a direction is identified in the Oxford Dictionary as a position towards which a person moves or points, and refers to guidance or supervision. A direction does not require to be in writing and may also include verbal instructions. It appears to be focused more on immediate or short-term action.
Just on that, General, was the disbandment instruction a direction as envisaged in Section 2072 of the Constitution? If not, why? I am aware that from paragraph 93 onwards, you do deal with the question whether the disbandment instruction was a policy or an operational matter. You do not deal, however, with the question of a direction. That is from 93 onwards. Hence my question.
Okay.
So was the instruction a direction or not? And why not?
Chair, clearly it was an instruction by the Minister. It also contained the word, I believe repeatedly, direct. The question is, was it a lawful instruction or direction, in the sense, did the Minister have the power to direct or command the closure of a task team that was investigating crimes? And in my view, he did not have that authority, because it relates to the operations, investigating cases, and the operations of the police. In other words, the execution of the police's mandate in terms of Section 205(3). If we say the National Commissioner is responsible to manage and control the police service, that must be linked to manage and control the police service in the execution of its constitutional mandate. And the decision of a minister to close a political task team that was responsible for the investigation of crime, in my view, fell outside the mandate or authority of the minister.
So in short, what may be purporting to be a Section 2072 direction cannot be such a direction if it has strayed onto operational matters.
I agree with that submission or with that explanation, Chair.
Well, if I can just come in, it's not even a question of agreeing. I think the chair is simply paraphrasing your statement and the proposition that you put.
Okay.
So
confirm.
Yes. I think lest the chair be misunderstood to say he put a particular suggestion. Thank you, Chair.
Sorry, Mr. Mdau.
Yes.
General, two questions from me. One about directions. What would constitute a direction that does not offend, a direction from the minister that does not offend the constitutional structure?
Commissioner, in my view, especially if you consider public engagement, such as in BIZOs, will be a place where the minister engages with the community. And if a minister, for example, during such an engagement with the community finds out that there's unhappiness, for example, in the Western Cape with gangsterism, and the minister tells the National Commissioner, you have to do something about gangsterism, that would be a direction. In my view, it will be a positive direction coming from the evaluation of complaints or engagements that the minister had, and this can be with the community or it can be with the politicians in the province. And that direction is based on what he was told by members of a community or members of the executive in the province, identifying a specific area of concern or where there's a problem, and simply telling the National Commissioner, you must do something about this, or attend to this, look into this. As I said, gangsterism, I believe, will be an example that all of us can identify with.
Okay, so not the how?
Not the how, no. Okay. And I would also be careful to say that the minister can close things. In other words, that can have an impact on policing. So if he makes a positive suggestion or a positive guidance to say, look, or what can you do about this? But to close something may have a ripple effect that is not something that is anticipated by a politician when that decision is taken, simply because he's not, he cannot be expected to be aware of all the intricacies of policing and how one decision can impact on a number of other aspects of policing.
And the second part, in your paragraph 26, that opening sentence where you say the need for clarity on the role of minister has repeatedly, with emphasis on repeatedly, been raised as a concern. This, I don't know if this is the intention that you sought to convey, but it suggests this is not a once-off, the case that we're dealing with now, or the facts that we're dealing with now. It's not a once-off thing. There's been concerns. If you like, systemic concerns about the role of the minister. Is that what you're seeking to convey there? And if you do, if that's what you're seeking to convey, what are the specifics?
Commissioner, to be honest with you, I think it was more within the context of the last couple of months that we've been consistently working and attending to the issue of the closing of the task team and the implications thereof. So there wasn't any strange intention to include the word. I think it's just something that is constantly part of our daily operations. And I believe the implications of that letter and the fact that we are sitting here today indicates the need or amplifies the need for clarity, not only for the benefit of the organization, but also for the benefit of the executive, to ensure that there's a clear line to stay away from in respect of both the National Commissioner and the Minister, but also for the organization as a whole.
Your answer suggests that until recently, the recent incidents with past ministers, there's not been the kind of concern about the roles of the minister.
Well, the role of a minister has previously been highlighted, not only in the police, but in the Africa report on the July 2021 unrest, and the fact that the report or the commission held that there was an overstep of boundaries in the roles of the ministers during the policing of or steps taken to address the unrest. So it's not something that is completely new, and it's also not something that's only been identified in the police. It has been identified in other commissions as well.
Thank you, Mr. Malloy. In your interactions with the commissioners, you indicated that your misgivings relate to the how part. Can I ask you to perhaps complete that by dealing with whether can a minister, even assuming that his letter constitute giving direction as contemplated by Section 207, could he competently direct the when aspect?
No, he
as opposed
cannot.
to the how. In other words, when.
No, he cannot, because once again it will have operational implications. The whole issue of the continuation of investigations. Let me give a very simple example. That court case that was supposed to be heard on the first working day in January, what should have been done with that case? Should the investigator have simply withdrawn and say, I'm not involved in this investigation anymore? If there was a bail application, should the investigator say, I'm no longer authorized to, as a member of the political task team, to attend to this matter so that there's no one in court to oppose or to assist the prosecutor in opposing bail? So the practical implications of that, in other words, the immediately and also the how, is definitely problematic, and it shouldn't be left to the executive in view of the implications that it will have on policing.
But surely that would depend on the nature of that which has to be done. I know something like acts of torture, for example, are addressed as a matter of law elsewhere. But if despite the existence of such law, the minister is of the view that torture is committed by the police, what would be wrong if the minister were to say, I am issuing this direction and I am saying this must stop immediately? I'm just giving that as one example to make the point that surely it would depend on what the direction is about, and you cannot in a blanket manner say that it can never be immediate when it's issuing from the minister.
Chair, I agree, but in your example, torture is already an offence, so the minister cannot...
That's exactly why I preface what I say by saying, with torture, there's already law about it.
Yes.
I would imagine that, put it this way, one cannot discount the possibility that there may be any number of other examples that may require immediate action, which may not necessarily mean that that becomes unlawful purely because the minister says this must happen immediately. That's all I'm saying.
Yes, I agree, but even in those circumstances where an immediate action is required, the decision must be rational, and rational requires it must have a lawful basis, and also it cannot be arbitrary. And I believe
I'm very sorry to interrupt you. That's something else altogether. I'm just making the simple point that surely it should depend on the nature of the direction being given. Yes, of course, whether or not it's lawful, it would have to comply with the law, including the Constitution. You are touching on irrationality. That's something that would be unconstitutional in terms of the Constitution. But that doesn't address the debate you and I are having now, which is that surely it may depend on the nature of the direction, and depending on that nature, in certain instances, the minister can be able rationally and lawfully to say this must be done immediately. This must stop immediately. Surely you cannot discount those possibilities. Otherwise, I'm not taking away from your point, but I'm just saying that you should not make the point so categorically as to discount those possibilities.
Chair, I agree. Circumstances may dictate that immediate action is required.
Yes.
Thank you, General.
Thank you.
Mr. Mtawi, just last one for me, just to make sure I understand. General, if the minister had said, and let's come specifically to the PKTT instruction, if the minister had said to the National Commissioner, I want the political killings, the political killings that are the focus of the PKTT to now no longer be a priority in the list of priorities, no longer be your priority. Here's a new priority that I want you to focus on. If that's what he had said about the PKTT, would that offend the separation of policy and operation? Would you complain if the minister had said that?
Chair, in taking the cue from Commissioner, in taking the cue from the Chair, I believe there may be circumstances where that is required. However, I also want to be careful to say that will also be always the case. But I fully understand there may be circumstances. Let's say there's a huge explosion tonight and a city is completely obliterated. Then the minister may say, don't attend to this, immediately go there and attend to that matter in view of the urgency of the matter, to simplify your example. So that may in circumstances be required. But I am hesitant also to say that will always be the case. I think we need to consider the circumstances of a specific incident.
Thanks. And I think moving from that part, that there can never be a general blanket exclusion, that there may be circumstances where a minister may competently issue directives or give direction by way of policy. If I could then ask you to move from that point and continue with paragraph 28 of your statement.
While neither Chapter 11 of the Constitution nor the SAPS Act provides for clear guidance on the ambit or scope of a policy or directives that the minister may issue, it is important to note that Section 85 of the Constitution deals with the executive authority of the Republic. Section 85(2) provides that the President exercises the executive authority together with other members of Cabinet by implementing national legislation except where the Constitution or an Act of Parliament provides otherwise, by developing and implementing national policy, by coordinating the functions of state departments and administrations, by preparing and initiating legislation, and by performing any other executive function provided for in the Constitution or national legislation. Section 92 of the Constitution provides that members of the Cabinet are accountable collectively and individually to Parliament for the exercise of their powers and the performance of their functions, and must act in accordance with the Constitution and provide Parliament with full and regular reports concerning matters under their control.
And then you proceed in paragraph 31 to conclude by providing your views subject to the qualification that you stipulate therein. If I can just ask you to deal with that.
In my view, which I offer purely for purposes of assistance, while I note that the issue relating to the proper implementation is reserved for the commissioners.
Interpretation.
Relating to the proper interpretation is reserved for the commissioners. The role of a minister, according to me, is therefore to provide national direction on a strategic level in accordance with government policy.
And the next key role player within SAPS that you deal with is the National Commissioner, and you commence with that from paragraph 32.
In March 2022, President Cyril Ramaphosa appointed Lieutenant General Fani Masimola as the National Commissioner of the Police.
And he thereby became a full general.
That is correct, sir. Section 11 of the Police Act details the responsibility.
Sorry. Chair, I'm not sure whether can we use the English expression that he was then generalized with effect from that.
He was actually specialized by becoming.
Thank you. Yes, please proceed from paragraph 33.
Section 11 of the Police Service Act details the responsibilities and powers of a National Commissioner in managing and controlling the police service, including developing annual policing plans, determining the police's structure and numbering of posts, distributing its members, and maintaining training and operational institutions. The Police Act was amended by the South African Police Service Amendment Act in 2012, which clarified that the National Commissioner exercises control in accordance with the Constitution. I particularly highlight the following features as alluded to in the affidavit of a National Commissioner. And if I recall correctly, this was a matter raised by Commissioner Kumalu during the testimony of a National Commissioner. The National Commissioner holds the ultimate authority to control and manage the entire police service in accordance with the National Policing Policy and directives from the Minister of Police. And this is provided for in Section 207 of the Constitution. The National Commissioner ensures the police fulfills its constitutional mandate, which includes preventing, combating and investigating crime, maintaining public order, protecting people and their property, and upholding and enforcing the law.
General, in 34.1, when you say holds the ultimate authority to control and manage the entire police service, would that include the Deputy National Commissioners?
Yes, indeed, sir.
And when you deal with this evidence, can you also deal with their role as well? Because I see that after this section, you go to the provincial commissioners, but you don't say a lot about the deputies.
Okay.
And that is important in the context of the allegations made against General Sibia.
Okay.
And what authority he had to do certain things.
Okay. Yeah. Commissioner, do you want me to deal with it now, or can I go through the key responsibilities?
You can go through them and then deal with it afterwards.
Okay. The National Commissioner is also, yes, I dealt with the constitutional mandate, strategic leadership. The National Commissioner is responsible to maintain an impartial, accountable, transparent and efficient police service in accordance with Section 25 of the Police Act. The recruitment, appointment, promotion, transfer and discipline of employees of the police service, including the appointment of provincial commissioners. And these matters are addressed in Chapter 9 of the Police Act, Section 207(3) of the Constitution on the appointment of provincial commissioners, Section 8 of the Police Act on the loss of confidence in a provincial commissioner, as well as in the South African Police Service discipline regulations, dealing with discipline matters of employees of the SAPS, except where specific provision is otherwise made in the Police Act, and Chapter 4 of the South African Police Service employment regulations.
Yes.
The National Commissioner is also responsible to ensure the provision of vital services such as crime intelligence, criminal records, crime statistics, and forensic laboratory services. This is contained in Section 218 of the Constitution of South Africa, the interim Constitution of 1993. And that provision has been retained in accordance with Item 24 of Schedule 6 of the 96 Constitution, the transitional arrangements.
And you've headed that operational support.
Yes.
Please read your headings as well.
Sorry, Chair.
I'm saying you did not read under 34.5, you did not read operational support, which is, I don't know whether
The
you
lead.
call it, whether you call the lead.
Yeah, the lead.
Yes, the lead to what you read.
Okay.
For the record, I think we do need that, yeah.
My-
Like, for
my
instance,
apologies.
34.3, strategic leadership, and then.
Okay,
what
okay,
you
my
have.
apologies.
34.4, personnel management, and then you go into what you have, and so on.
Can I continue from 34.6 with the correct?
Yes, please.
Okay.
Yes.
The National Commissioner is responsible for internal security, the maintenance of internal security of a nation in accordance with Section 2181C of the Interim Constitution, as well as international cooperation, international police liaison to facilitate cooperation and information exchange in accordance with Section 2181E of the Interim Constitution. The National Commissioner reports, its reporting structure relates to the direct reporting to the Minister of Police as the executive authority responsible for policing in terms of Section 206 of the Constitution, and the President as the authority who appoints the National Commissioner in accordance with Section 207 of the Constitution. In this regard, it should also be mentioned that the employment contract of the National Commissioner is concluded with the President in terms of the police employment regulations, and the President is responsible to deal with the loss of confidence in the National Commissioner in accordance with Section 8 of the Police Act. The National Commissioner also accounts to various institutions such as Parliament in accordance with Section 55(2) of the Constitution, and various other legislative oversight bodies, including Chapter 9 institutions, in accordance with their respective mandates as set out in legislation.
Yes, then can I request, from paragraph 35, you say, in addition, I believe it will be prudent to highlight certain specific powers of the National Commissioner. If you could deal with 35.1 until 35.6, and perhaps thereafter address the question that is raised by Commissioner Khumalo, that of the Deputy National Commissioners,
Okay.
before you deal with your concluding 2 paragraphs thereafter. Please proceed from 35.1, strategic planning.
Thank you, Chair. Strategic planning, the National Commissioner develops a plan at the end of each financial year outlining policing priorities and objectives for the following year. And this is provided for in Section 11(2)A of the Police Act. In addition, the National Commissioner is responsible to structure the service. He determines the fixed establishment of the police and the number and grading of posts within the organization, as provided for in Section 11(2)B of the Police Act. The allocation or distribution of resources is another responsibility, and he decides on the distribution of the services numerical strength after consultation with the board. This refers to the Board of Commissioners as contemplated in Section 10 of the Police Act. Organizational setup, the National Commissioner organizes and reorganizes the police service at national level into various components, units and groups. For example, the National Commissioner can decide to organize and arrange certain divisions together. Like currently we have one division called Visible Policing and Operations, and it used to be Visible Policing and Operational Policing separately. So we can arrange and rearrange. And this also means in respect of crime intelligence, the National Commissioner can decide how he wants crime intelligence to be structured as part of the broader structure on national level. The National Commissioner is also responsible for institutional development. He establishes and maintains training institutions for the training of students, in other words, new recruits, and members, in other words, in-service training of existing members. And this is authorized in terms of Section 11(2)E of the Police Act. Then finally, the maintenance of institutions. The National Commissioner establishes and maintains institutions necessary for the service's overall management and maintenance, such as bureaus, depots, workshops, and other facilities.
Then if I could ask you to pause there. If you go to page 20 of your statement, you provide a pictorial depiction of the top management structure within SAPS, and part of the positions that you depict therein relate to the Deputy National Commissioners. If I could then ask you by way of interposing your evidence to deal with the Deputy National Commissioners, and what do they do and what are they responsible for?
Okay. The Deputy National Commissioners, there are currently 3 Deputy National Commissioners. They are in terms of Regulation 8 of the South African Police Regulations, in order of precedence, directly below the National Commissioner. The organization currently provides for a Deputy National Commissioner responsible for policing. In general terms, that means police officials that wear uniform. That relates to General Mosekiri's responsibility. That would, for example, be visible policing. It will be frontline police officials who work at police stations, attend to complaints. It will also be border policing units, in other words, wearing uniform. The Special Task Force, National Intervention Unit, and Public Order Policing. Typical police officials that you see in uniform, reports through the relevant structures to the Deputy National Commissioner for Policing. Then the second Deputy National Commissioner is crime detection. That is General Sibiya's environment. That deals more with the investigating part. So that will be the detectives, forensic services, it will be protection and security services, as well as crime intelligence reporting to that Deputy National Commissioner. So General Mosekiri dealing with the crime prevention part, and General Sibiya with the investigating part of a mandate of the police. And then the third Deputy National Commissioner is responsible for support services, and that Deputy National Commissioner deals with the support environments. For example, human resource management, human resource development, which is the training part of the police, also responsible for legal services, supply chain, and technology management services. In other words, all the support services to enable the frontline police operational environments to execute their functions effectively.
Now, do the Deputy National Commissioners account to or report to the Minister?
No, the Deputy National Commissioners report to the National Commissioner, and the National Commissioner reports, as the head of department, reports to the Minister.
Can the Deputy National Commissioners say, once a Minister has issued a directive, we are obliged to A, comply with it, B, implement it, notwithstanding what the National Commissioner says?
No, the Deputy National Commissioner does not have that power. And I am reminding you, Commissioner, that Section 199(6) of the Constitution says no member of the security services may comply with a manifestly illegal order. So the fact that it came from the Minister and it didn't fall within the purview of a Minister to give that order is already problematic. The correct approach would have been to report it to the National Commissioner and to say, I've received this order from the Minister and I'm reporting it to you to give direction on how to deal with the matter.
You do deal with this issue later on in your statement when you deal with bypassing.
That is correct,
yes,
sir.
If I could just take you back to your statement. Let's proceed from page 16, paragraphs 36 and 37.
At this juncture, I pause to note that clear constitutional distinction exists between the political responsibility of a minister and the operational control of a national commissioner. The minister focuses on policy, governance, and political accountability, whereas the National Commissioner controls and manages the day-to-day operations of a police service in accordance with the Minister's policy directives. This structure...
Sorry, General, I may be mistaken. I think you are using the term policy directives for the first time. Perhaps Advocate Siegels Nube could help us with the word search. Control, find, and see if it does appear before now. But let me continue so long. By directives, are you referring to the same thing as directions, which is the word referred to in section 2072, or is your idea of directives something different?
Chair, my idea is, as I explained the directives earlier in my testimony.
I'm asking a direct question. Is that the same thing as a section 2072 direction, or is it something different?
That is the same thing, in my
Same
understanding, yes.
All right. Now, you seem to collapse what appear to be two concepts, collapse into one, what appear to be two concepts in section 2072. Section 2072 refers to policy and directions. The very fact that the Constitution puts them like that suggests that they are separate concepts. I do not know, perhaps through an interpretative exercise, one could say there isn't really a difference, I don't know. But the Constitution says policy and directions, and you've suddenly collapsed them into one, policy directions. In fact, you simply use policy now as an adjective, qualifying the noun directions, so that what for you appears to be the most important concept is directions.
Yeah.
So policy is merely adjectival, whereas the two appear to be two separate concepts. Do you want to please comment on that?
Chair, I concede. You are correct. The policies, as I explained, are more long-term written documents. It gives the goal, the government's goal, to achieve certain objectives, albeit in the national policing policy, or the example that I utilized to remove barriers in the reporting of certain offences, and it aims the implementation by the police of long-term goals. These are not things that can be achieved overnight, but it is constant goals that should be entrenched in the police, in its operations, working towards that goal and ultimately achieving it. That would be my understanding of policy. Whereas directions are more short-term, immediate action. As I indicated, it can be written or verbal. What are you doing about gangsterism? I need a report, or I need you to do something about this. And in that regard, my statement may unnecessarily have caused confusion, for which I apologize.
No problem at all, General. I've actually also been exercising my mind over what these mean. I know General Masemula did give his interpretation. You have given your interpretation as well. And when you were engaged by my colleague, Commissioner Baloyi, and you gave an example of what you understand to be a direction as envisaged in section 2072. I was interrogating within my mind the question whether, for example, the example you gave cannot actually also be policy. For example, if the minister says we should no longer prioritize such a crime, or we must prioritize such a crime, it's very difficult for me to say that's not policy. It's only a direction. It seems to me it may actually be both policy and a direction. I'm just stating that to say that this is an issue that raises serious interpretation issues.
Yes.
I'll leave it at that. I won't ask you to comment. Thank you, Advocate Mutau.
Thank you, Chair. If you can just conclude by pulling 36 and 37 together,
Okay.
And then with the leave of the chair and the commissioners, it's almost tea time.
Chair, in conclusion, this structure is intended to ensure political accountability, but insulating the police operations from undue political interference. And I think that is ultimate, the goal of getting that line right, to ensure that there is accountability, but not interference in policing.
Thank you. Perhaps we should adjourn at this point and resume at 11:15. Let's adjourn.
Adjournment, we're concluding in paragraphs 36 and 37. And just to reorientate ourselves, the evidence that you were giving and the point that you were making was that your evidence does not seek to conflate or to collapse both policy and direction into one thing. But the import of what you're trying to put across is that both are intended to cure the mischief of avoiding political interference. Is that correct?
That is correct, Mr. Madal.
But, if we can then go to the next topic that you deal with from paragraph 38.
Before you do that, Mr. Madal, General, where you speak about, and I'm looking at paragraph 34, the sub-paragraphs in 34. And the question I'm going to ask relates to a topic that I know you deal with later on, but I just want to establish the principle of the principle of it, if you like. We know that in the letter from the minister, the letter of the 31st, that letter includes an instruction not to fill vacancies in crime intelligence. I know you deal with that, so I'm not asking you to deal with the merits of that instruction. Where would the filling of vacancies, whether crime intelligence or whatever, fall under where you're discussing the powers, functions, and roles of the National Commissioner? I've looked at 34.1, 34.4, 34.5. And does it fall anywhere in those or in another discussion under paragraph 34?
Thank you, Commissioner. It falls under 34.4, under the appointment promotion. And that is regulated in Chapter 9 of the Police Act, as well as the employment regulations.
And in making decisions about filling positions, is the National Commissioner required to consult with the Minister?
It depends on the level. Lower levels, no. But if it is from Major General upwards, excluding Provincial Commissioners, then the appointments must happen in consultation. In other words, there must be consent and agreement from the Minister, and that is regulated in the employment regulations in Regulation 48, 38.
Thank you. Thank you, Mr. Mta.
Thank you, Commissioner Baloyi. Yes, the next key role players in SAPS, you say, commencing from paragraph 38, are the provincial commissioners. If I can ask you to proceed to deal with those.
Section 12 of the Police Act outlines the powers and responsibilities of a provincial commissioner who commands and controls the police service within his or her respective province, including the establishment and maintenance of police stations and units, and determine the strength distribution of a service under his or her jurisdiction. It should also be mentioned that Section 219 of the Interim Constitution, which deals with the mandate of a provincial commissioner, subject to the mandate of a national commissioner to control and manage the police service, has been retained in terms of item 24 of Schedule 6 of the Constitution. That's Schedule 6 deals with transitional arrangements. The South African Police Service Amendment Bill, which is currently in the final stages before introduction in Parliament, proposes substantial amendments to Section 12 to clarify the Provincial Commissioner's authority to act on the directions of a National Commissioner. For the benefit of the Commission, I highlight the following. Command and control. Provincial Commissioners shall have overall command and control over the police service within their provinces, subject to the power of a National Commissioner to exercise control over and manage the police service in accordance with Section 2074 of the Constitution.
And perhaps if I can just stop you there. This section is going to become important when we deal with that instruction by Lieutenant General Sibia for the withdrawal of the dockets and their transfer from KZN to head office. I'm not asking you to deal with it now, because I know you deal with it later. If I can then ask you to proceed from 40.2, establishing police infrastructure.
Provincial commissioners are responsible for establishing and maintaining police stations and units within their jurisdiction, in accordance with Section 12(2)(b) of the Police Act. Determining strengths, provincial commissioners determine the distribution of police personnel and resources across different areas and units under their command, in accordance with Section 12(3) of the Police Act. Constitutional alignment, the duties of the provincial commissioners are performed to give effect to the provisions of the Constitution, particularly the command and control functions of the service. This is set out in Section 12(1) of the Police Act. Just to indicate, of course, the provisions of the Constitution also means that provincial commissioners must focus on the objects of a police service, and their operations and their management must be in the furtherance of a mandate of the police as set out in Section 205(3) of the Constitution. Directions from the National Commissioner, provincial commissioners operates under the direction and authority of a National Commissioner, a role that has been emphasized in the amendment to the Police Act. And this is set out in Section 207 of the Constitution. Crime prevention, a provincial commissioner is responsible for the prevention and investigation of all crimes or alleged crimes committed in the province. Where an investigation of a crime or alleged crime reveals that it relates to organized crime, the provincial commissioner is required to report the matter to the national head of the DPCI, who may, at his or her discretion and after consultation with the provincial commissioner concerned, direct that the investigation or any part thereof be conducted by the provincial commissioner in accordance with Section 16(4)(a) of the SAPS Act. In order to ensure accountability, each provincial commissioner must report to the provincial legislature annually on policing in the province and must send a copy of that report to the national commissioner, as required in Section 207(5) of the Constitution.
Sorry, General, I don't know, maybe it's the same point that Advocate Mtau was raising and he said you will deal with later on. Just looking at the organogram on page 20, reading it with paragraph 40.5 of your statement. Do provincial commissioners operate under the direction of the deputies, or where do they rank in the hierarchy?
They report directly to the national commissioner.
So they cannot take directions or instructions from the deputy national commissioners?
Commissioner, when, as I indicated, let's say General Sabia is responsible for investigations as the Deputy National Commissioner, if he requires the assistance of a provincial commissioner, he can call the provincial commissioner and say, I need your assistance on this, or there's dockets that we need from head office side for this purpose or whatever. So there will be consultation, but when it comes to the reporting and their performance as well, they report directly to the national commissioner.
Well, perhaps just to follow up on that point, and maybe put it here, is it competent for a deputy national commissioner to give instructions in a province for the upliftment or the transfer or removal of dockets without engaging the provincial commissioner of that particular province to which the dockets relate?
No, sir, it will not, because then it means there are things happening in the police that the provincial commissioner is accountable for, but he doesn't have any knowledge of that. So that is problematic. It undermines the authority of a provincial commissioner to effectively manage the police within that province.
And in fact, the commission will recall when the national commissioner testified on that aspect, he indicated that when that issue, the issue of the referral of the dockets back to KZN was being dealt with, he said to Deputy National Commissioner Sibia, they should be retained the same way that he took them. In other words, because they were removed without the involvement of the Provincial Commissioner, their return should also not involve him.
That is correct.
General, just a follow-up on that. In this case of the PKTT, where, as I understand it, General Khumalo, sitting at National, is the head, or whatever language you want to use, for the PKTT. Can it not be validly argued or contended that General Sibia acted properly by instructing General Khumalo, because he's not sitting at province? Yes, it relates to the PKTT, but he's sitting at National. Would you still say it's inappropriate that, forget the merits, the lawfulness of the instruction, I'm speaking structurally, that could General Sibia not validly instruct General Khumalo, who is responsible for the PKTT, to deliver the dockets to him?
Commissioner, keep in mind that the General Khumalo is the project leader of the task team, and he was appointed by the National Commissioner. So my understanding would be, if there's any direction given or instructions given to avoid the word direction in view of our discussion, if there's any instruction or commands given relating to investigations, it should come from the National Commissioner as the person who appointed that task team and who oversees, even if it is just in a reporting phase, their performance. So that would be the appropriate manner. And keep in mind that the National Commissioner can easily appoint a police official to deal with a task team. So it doesn't always relate to the fact that whether he's at national level or whether he's in the province. The fact that he was appointed by the National Commissioner for that specific task means that he needs to report and take instructions from the National Commissioner on that matter.
So the National Commissioner, you wouldn't fault the National Commissioner, and I'm speaking overreach, you wouldn't fault the National Commissioner if he had been the one that gives the instruction to General Khumalo and not through General Mkhwanazi?
Yes, that would have been the appropriate procedure to deal with it, yes.
Thank you.
If I can just clarify, I'm just thinking now, I mentioned earlier of a question related to dockets, if dockets were to be transferred. Let's say there's a serial killer that operates in Gauteng and in Northwest. Then you want to consolidate the dockets under one province or one station so that the investigation can be done in a proper manner. Otherwise, you duplicate the investigation. So in that case, there may be discussions either from head office with the provincial commissioners, or even the two provincial commissioners between themselves will say, listen, I hear you've got 3 dockets, but we've got 10. So please, can we transfer those 3 so that we consolidate the resources and deal with it within our province? So it's not unheard, but there must be proper consultation. The provincial commissioner cannot simply come in, or even from head office, and just take dockets. It would not be appropriate for a functionary to deal with it in that manner.
Thank you. Then proceed to paragraph 42, where you conclude.
I emphasize that this distinction in roles is important as it enhances provincial autonomy and accountability by granting provincial heads of a police service the authority to manage their forces, meaning police service, while also ensuring they are accountable to the national leadership. It enhances operational effectiveness, and this section ensures that resources are deployed efficiently and effectively across the province to meet local needs and maintain public order.
Okay. And then the next section where you identify key role players within SAPS, insofar as the engagement is concerned, are provincial MECs, and from paragraphs 43 and 44, you outline what the provincial executive is responsible for insofar as policing is concerned. And you also deal with, in 44, SAPS organizational structure, which is set up to ensure effective law enforcement according or across South Africa. Then you deal with the hierarchy and how it is comprised, and the 9 provincial commissioners and the various district commissioners, station and unit commanders, all managed and overseen by the national commissioner. Then you thereafter deal with that pictorial depiction of SAPS's top management, which we skipped or jumped to earlier on, you recall, so we don't need to go back there. The next topic that you address is then that of oversight framework regulating SAPS. Bearing in mind that one question that we're looking at, which you deal with towards your conclusion, whether on the facts of what the Commission is dealing with, is it the question of lack of oversight mechanisms that are there, that are responsible for what has brought us here? So that is where we are heading. Yes. But if I can then ask you to deal with the oversight framework that regulates SAPS, you commence from paragraph 46, if you can take it from there to paragraph 50.
SAPS is extensively regulated by various statutes. From an operational point of view, this ranges from legislation conferring powers on police officials, such as the powers to arrest, search and seizure, which are important to ensure the effective execution of a constitutional mandate of a service as set out in Section 205(3) of a Constitution, in particular to prevent, combat and investigate crime, and also to uphold and enforce the law. In addition,
okay, yes, please proceed.
Numerous pieces of legislation regulates coordination, reporting and oversight measures in respect of a SAPS. In this context, the following is highlighted. The secret services...
Sorry, perhaps might I just get guidance from the chair and the co-commissioners? From 47.1, the statement refers to the various pieces of legislation. That's 48.1 to 48.5, and then 49 deals with internal policies and strategies. And I'm just trying to see whether can we take them as read into the record so that the witness does not have to list each of them.
Unless there are some that are relevant to the terms of reference.
Thanks. Perhaps if for now we can say those are taken as read, General, unless you are of the view that there are some that requires some emphasis, you can do that.
Chair, I don't think it would require specific emphasis. However, I do want to point out that 47.8 refers to the Public Administration Management Act, and that it contains a typo. It is not 2024, but it is 2014, the citation of the Act.
And other than that, is there anything that requires emphasis going up to paragraph 49.9?
No specific aspect that I believe should be emphasized.
Then taking the cue from that policy direction that was given by the chair and the commissioners, we will skip those. Then you conclude in paragraph 50, you say in the following sections and based on the above, you now tend to discuss the various oversight mechanisms. These include parliamentary oversight bodies, Chapter 9 institutions, as well as the SAPS internal and ministerial oversight mechanisms. If I could ask you to then commence after paragraph 51, where you say, in order to give effect to the principles of transparency and accountability, various bodies and entities exercise oversight over SAPS. These include parliamentary oversight measures, Chapter 9 institutions, oversight by other departments within the Ministry of Police, Provincial and SAPS internal regulatory functions. If I can just ask you to then, under the heading of parliamentary oversight and a number of parliamentary bodies regulate SAPS, you start with the Portfolio Committee on Police. If you can commence from paragraph 53.
The Portfolio Committee on Police is established in terms of section 55(3), or 55(2), I apologize, and 57 of the Constitution, and are responsible for the exercise of parliamentary oversight over the police within the National Assembly. A select committee on security and justice is responsible for such function in the National Council of Provinces.
And before you go on, General, just a correction, unless you disagree. I do not think Section 57 deals with the establishment of the Portfolio Committee. I read it to deal with internal arrangements, proceedings, and procedures of the National Assembly. So that's not about establishment.
I apologize, Chair. I think the intention was to indicate the regulatory framework of the rules that are established in 57, but you are correct.
Thank you. Thank you.
These entities exercise oversight through parliamentary questions directed at the Minister of Police, meetings where the SAPS is required to appear to explain and account for certain police action, as well as oversight visits, announced and unannounced, that are conducted by the Portfolio Committee. And the Portfolio Committee on Police has published guidelines specifically relating to oversight visits and the manner in which they are to be conducted. A provincial commissioner is furthermore required in terms of section 207(5) of the Constitution to report to the provincial legislature annually on policing in the province. Then in addition to the Portfolio Committee, there's also a Standing Committee on Public Accounts, SCOPA, that considers financial statements of the executive organs of state and constitutional institutions or other public bodies when those statements are submitted to Parliament. SCOPA is empowered to report on financial statements or report to the National Assembly, initiate an investigation in its area of competence and perform functions, tasks and duties assigned to it in terms of law. In addition, there's a joint Standing Committee on Intelligence, and that committee is established in terms of Section 2 of the Intelligence Services Oversight Act. The committee performs oversight functions in respect of the intelligence and counterintelligence functions of, inter alia, the crime intelligence in the police, as well as military intelligence and the SSA. In the discharging of its functions, it considers the administration, financial management, and expenditure incurred inter alia by the different security or intelligence agencies, and specifically the Division of Crime Intelligence. Then in addition to that, there's...
you deal with statutory oversight?
Statutory oversight.
As your next topic?
The Office of the Inspector General of Intelligence. The Office of the Inspector General of Intelligence is appointed by the President in terms of Section 210B of the Constitution, read with Section 7(1) of the Intelligence Services Oversight Act. The Inspector General of Intelligence is responsible to investigate complaints relating to the conduct or behavior of members of intelligence services on alleged maladministration, abuse of power, transgressions of the Constitution, laws and policies on intelligence and counterintelligence, corruption and improper enrichment of any person through an act or omission of any member of the intelligence services, and to report thereon to Parliament. Referrals to the Office of the Inspector General of Intelligence are made from the Human Rights Commission, the Independent Police Investigative Directorate, and the Public Protector in cases where the complaint relates to any of the intelligence services, and they also report thereon to Parliament.
And then in the next section or topic of your statement, you refer to Chapter 9 institutions. You list them in paragraph 61, and in 62 you indicate that each has a separate legislation which regulates its powers and functions and also outlines its mandate. And if you go over the page to 63, you then conclude in paragraph 63.
SAPS must, in accordance with Section 181(3) of the Constitution, assist and protect the Chapter 9 institutions to ensure the independence, impartiality, dignity, and effectiveness of these institutions.
Then you proceed to deal with ministerial oversight,
Before we
commencing.
get to ministerial oversight, Advocate Mutau.
Yes.
General, in the section where you're dealing with parliamentary oversight, are you suggesting that there was a failure there? What's the point of this section? Because the conclusion then just tells us that there is this oversight and there are these bodies in place. Would we be sitting here today if they function properly? You can give your opinion. If you don't wish to express one, you can say so.
Commissioner, I believe that the issue that General Mkhwanazi publicly announced on the 6th of July was previously reported during a PCOP meeting in March, if I remembered correctly. So the fact that the Portfolio Committee didn't act on that is, in my mind, a failure of their mandate. Even if they initiated an investigation, called the management of the police to come and explain, that would already have been an exercise of oversight on their part to ensure that the matter received attention.
In fact, you'll recall also the National Commissioner gave evidence to that effect when he was asked whether upon Lieutenant General Mkhwanazi making those disclosures, because you recall he had been called premised on an interview that he had given to ENCA, and he testified that there was nothing that was done by the Portfolio Committee to deal with the issue that had arisen and had been brought to its attention.
That is correct, sir.
Mr. Mutau,
Yes.
sorry, can I just on this? Isn't that what they're doing now? I mean, we know there's a committee that has been set up and which is doing it. I think it's called an ad hoc committee. Is that not what they're doing now?
Keep in mind, Commissioner, that it's an ad hoc committee, so it cuts across not only in respect of the Portfolio Committee of Police, there's also members of the Portfolio Committee on Justice. But it is part of their constitutional mandate or their legislative mandate of oversight. I think the issue raised by Commissioner Khumalo, as I understood it, was about the timing, the fact that it was reported. They have the power to call the management to account, to come and explain. And in hindsight, it's easy for me to say because I'm not a member there, but in my view, it would have been appropriate for the Portfolio Committee to call the management a week or 2 weeks after that incident to account, to say, give a report on what is happening and what exactly is being, what is the facts in relation to the allegations that was made by General Mkhwanazi in that meeting. That would have been part of a mandate, and I believe expected in the execution of their powers to conduct oversight, to call the department to account and to explain what the situation was.
And your comments refer specifically to the Portfolio Committee on Police.
That is correct.
Thank you, Commissioner Baloyi. If we can then proceed from paragraph 64, you were about to start with ministerial oversight, and you say, in terms of Section 208 of the Constitution, the Minister of Police is, apart from SAPS, also responsible for the CSPS and IPID. If you can please proceed from 65.
In terms of Section 208 of the Constitution, the Civilian Secretariat for Police is required to function under the direction of a minister or the cabinet member responsible for policing. It is established in the Civilian Secretariat, the department has been established in terms of a Civilian Secretariat for the Police Service Act. The Civilian Secretariat monitors the performance of a police service and regularly assesses the sufficiency of policies and systems, and they are also empowered to make recommendations on the effectiveness thereof. The department also advises and supports the Minister of Police in the execution of his or her powers and the performance of his or her functions. And the department reports to the Minister on the implementation and compliance by the police service with policy directives issued and instructions made by the Minister.
Yes, and then you deal with IPID next.
Section 206(6) of the Constitution provides that on receipt of a complaint lodged by a provincial executive, an independent police complaints body established by national legislation must investigate any alleged misconduct of or offence committed by a member of a police service in the province. IPID is the body established in terms of in terms of the Independent Police Investigative Directorate Act to give effect to Section 206(6) of the Constitution. It ensures independent oversight of the SAPS as well as municipal police services, investigate offences allegedly committed by members of the SAPS and municipal police services, and make recommendations relating to disciplinary action in respect of such members. Chair, if I can just indicate, there's a typo in paragraph 67. The citation of the Act is incorrect. It is Act 1 of 2011 and not 2010.
Okay, thanks. And then you proceed to deal with the internal regulatory framework from paragraphs 68 to 70. And there, among other things, you relate to, or you refer to the SAPS Code of Conduct in paragraph 68, and then you touch on Regulation 39 of the SAPS Employment Regulations, which regulates the general conditions of appointment. And in paragraph 70, you reference the SAPS regulations for DPCI, and whereafter you introduce the next topic that you deal with, which relates to the PKTT.
Again, Mr. Matau, before we go to the next topic, the section before with the various subsections or subheadings, General, are you aware of any report from any of those bodies mentioned in paragraph 65, 66, 68 that would have served before the minister and would have influenced the decision that was taken on 31 December 2024?
I am not aware of any report in that regard, Commissioner.
Because any of those entities, as I understand, could have investigated the conduct of the task team.
That is correct, within their mandate.
Within
yes.
their mandate.
Yes, sir.
And if there were any findings adverse to the task team, then those would have obviously been taken into account.
That is correct.
To determine whether it should continue to exist or not.
Yes, that is correct, sir.
And as far as you know, there is no report from any of those bodies.
As far as I'm aware, there's no report received from any of these bodies pertaining to their mandate raising complaints or concerns.
Thank you, Commissioner Kwan. And perhaps just to close that aspect, that if there were such reports, would you expect that their contents be put to the members of the PKTT, and by that I mean the three, at the very least, the National Commissioner, the Provincial Commissioner, and the Director Crime Intelligence as the project head of the PKTT, for them to address those concerns, if there were any, that the Minister would have had prior to taking his decision of 31 December 2024.
Well, sir, if I can go back to the oversight bodies, in the case of the portfolio committee, they will write to the minister. But when for example, let's say they complain about the police in any respect, the letter will be submitted to the minister as part of the part of cabinet, and then that letter will be cascaded to the National Commissioner to respond, because he deals with policing matters. So the National Commissioner will be in a position to gather the information, for example, and prepare a response for the signature of a minister to go back. In respect of the SCOPA, the police, the department itself will appear before SCOPA, but once again, because it's a parliamentary committee, they will write to the minister. But the other oversight bodies, for example, the Chapter 9 institutions, will write directly to the National Commissioner as the head of department. So it's not inappropriate to report any complaint or investigation that they are lodging directly to the head of a department for responses or to provide information. And in respect of the other departments, the Civilian Secretariat and IPID, normally they will approach the National Commissioner, and a copy of a report or letter will be submitted to the minister. So there's very few of that oversight bodies that will in isolation only approach the minister and not report or approach the National Commissioner directly in respect of a complaint or an investigation that is conducted within their mandate or scope of responsibility.
And earlier on...
Sorry,
sorry,
Mr. Mutawi.
Apologies.
In response to Mr. Mutawi, you say that senior management members who ought to have become aware, or rather, who ought to have been involved prior to the decision of 31 December 2024 being taken, were not involved. Now, are you aware whether there were any members of SAPS senior management who were involved before the decision was taken? And if you are aware, who are those?
I have no information in that regard, Chair. So I cannot respond but say I do not know. So I'm not aware that any member was approached or informed, and therefore I cannot give names because there's simply no information for me to give.
Is that odd?
Is
that is the fact that someone in your position is not aware at all. Is that not strange? Not strange in the sense that I'm criticizing you. I'm saying in terms of the processes. Is that not odd?
Well, it's difficult to respond, especially in view of the fact that I'm at legal services. It may have been in an operational environment, specifically within that chain of command, strange not to have a commander being informed or being made aware. So in that regard, I cannot really respond on the possibility that somebody knew about it, simply because it's a little bit distant from my area of responsibility.
I understand. Thank you, General.
Thank you.
Mr. Mutawi, before you proceed, in this communication matrix that you make, if something had arisen in the portfolio committee, as I understand you, then someone would write to the minister if it's a matter of concern that needs to be addressed, and the minister would then communicate with the National Commissioner. Now, from the evidence, as you're aware, that we've had now, you have Member of Parliament, I think it's Adams, is her name? The Member of Parliament? Yes, Member of Parliament Adams, who raised the matter and reported it to, and directed correspondence to the minister. We know from the evidence that the chief of staff then communicates with the DPCI, I think it is, and it results in its own process. It has its own process. Now, and I know that you deal with the question of the chief of staff later on in your evidence, and I'm not asking you to speak to the merits of it. I'm just trying to understand the systemic processes whether once a correspondence has been sent to the minister, are there processes or procedures that regulate how that communication that eventually must come to the attention of the National Commissioner, as you say, that regulates that process, how that is handled?
Commissioner, there is normally, it's just a matter of internal processes. It's not regulated or even formalized. It's not strange for the Chief of Staff if he receives, or if a minister receives a letter, for example, from a Member of Parliament, to submit it to the relevant environment, the National Commissioner's Office, and in the case of a DPCI, to their environment as well. For example, if a minister is in the province and that correspondent is received by his office, they will not wait until the minister returns to the office, let's say by next week, because that matter has to be attended to. So it's not unfamiliar processes for that letter to be submitted in view of the content and the topic. The Chief of Staff will make a call to say this is for the police, not for IPID or the Civilian Secretariat, and therefore submit it to the office of the National Commissioner for his attention. And in that regard, what we normally do is the department will prepare a response. They will investigate the matter, make a finding, and advise the minister by means of a draft response. And it has to be accompanied by an information note that basically explains to the minister this matter was received as a result of a complaint from a Member of Parliament. The information that we've gathered in our investigation of the complaint indicated the following. This is the process. For example, if let's say a parliamentarian complains about the docket, the detectives will be able to indicate where the investigation is. For example, it may be a bail application next week, indicating that information, and prepare a response, a draft response for the consideration of a minister, because that response has to follow the same path back as it came from Parliament. So the National Commissioner cannot simply respond to the Member of Parliament. It has to be signed and approved by the Minister and then returned to as a response to the initial complaint.
All right. Now, on the facts, or at least on the evidence before us, and I just want a more direct answer to a direct question. We know that the letter addressed is addressed to the Minister, and then the Chief of Staff writes a letter to the DPCI, signed by him, under the letterhead of the Minister, as I recall, of the Ministry, and then says to DPCI, investigate this matter. He has a criminal complaint. He has a complaint about criminal conduct. Investigate it. You're saying there's nothing irregular about that?
No, he may have consulted the minister telephonically, even if a minister wasn't in the office, but you can already anticipate that the minister will direct this. This is a complaint, it has to be investigated. And for that matter to be expedited to the relevant office to investigate it and to prepare a response, there's nothing untowards that it was sent by the Chief of Staff. Even in other offices, the support staff will consider a document and very often consult the manager, but will know this person is working with this matter or anything, or something similar, and dispatch it to the relevant office to deal with it. Ultimately, the response has to be signed by the minister. So it's not a matter of a chief of staff who decided how the matter should be dealt with, but at least the office responsible to investigate and look into that matter is then able to deal with it as soon as possible.
Thank you. Thank you, Ms. Mda.
Thank you. I think you've addressed your evidence on issues relating to rationality, which would include procedural irrationality and arbitrariness. I don't think we need to repeat that with regard to the execution or at least the communication of that instruction by the minister. But if I can ask you to then deal with the next topic from page 28, the political killings task team. And in this regard, the Commission has already had evidence regarding how the task team was formed, when it was formed. It has had at whose instance this commenced, leading to the establishment of the IMC, the various role players within IMC, and that culminating into the formation of the PKTT. And the two documents, sorry, the strategic plan which you attach in on page 76 is also an aspect on which the Commission has had evidence, including up to paragraph 79, relating to the second, more comprehensive strategy that was since developed. Now, if I can ask you to start, or perhaps just deal with paragraph 80, about the point that you seek to explain there.
I seek to explain that the establishment of task teams is a normal operational response by SAPS to address specific issues and challenges in the country. These may be constituted at the provincial or national level. The PKTT is one of many such project-based interventions. As I indicated earlier, for example, a serial killer may also necessitate the establishment of a task team, or illegal mining activities, or even cash in transit heists. If we find out that there's a problem, a policing problem, then a task team is very often a very effective manner to immediately address the policing challenge, to ensure that immediate action is taken to that problem, and to ensure that resources are allocated for that task team to perform its specific task.
Mr. Matau,
Yes.
sorry.
Thanks.
General, what is the difference between a unit of SAPS and a task team? Do the legal prescripts distinguish between the two? So that's my first question. My second one is the PKTT. Was it a national intervention or a provincial intervention? And what's the difference between the two?
Legally, there's no difference between a unit or a task team. And the fact is, very often a task team is a smaller group of people, cuts across different environments, for example, forensics and detectives, CI, which are all different environments, whereas a unit will have all detectives, for example. So a task team is more diverse. The second question, Commissioner, remind me, please.
Is the PKTT a national intervention or a provincial intervention? Because you say the paragraph 81 was one of the 11 national priority intervention operations operating in 6 provinces and one at national level.
Yes.
So I'm not sure whether PKTT is it a provincial or is it a national intervention, but operating in KZN.
I believe it was a national intervention because it came from the Interministerial Committee. And in that regard, it related to other departments as well, and it was reported to the minister. So it is a national intervention by the police. And then you had another question?
I think you may have answered.
Okay.
Answering the first question.
Thank you. You then indicate in paragraph 81 the provinces that are involved. And then in paragraphs 82 to 84, you deal, among other things, with the extension of the mandate of the PKTT, and you allude to the fact that incidents of politically related cases were expected to increase because of the 2024 elections, and you provide the reasons thereof, correct?
That is correct.
Then I'd like you to proceed to the disbandment instruction that commences from paragraph 85 of your statement.
On the 31st of December 2024, the Minister of Police directed a letter to the National Commissioner directing that the PKTT be disbanded.
Yes, and then that letter you attach as VR4 in Van Rooyen 2. It is at pages 101 to 103. You don't need to go there. You quote the aspect relating to political killings task team. You recall that that letter has 3 items that it deals with, one of which you also address later. But for purposes of this aspect of your evidence, you deal with the directive insofar as the political killings task team is concerned, which again, we don't need to read into the record because the Commission has had evidence and has seen a copy of that letter. And if I can just ask you perhaps to deal with paragraph 87 and following.
It is important to highlight that in his letter, the Minister did not direct how the dockets under the task team's control should be dealt with. He did, however, direct that the disbandment ought to be done with immediate effect. I am informed that this determination of the dockets under the task team's control should be dealt on how the dockets to the task team should be dealt with was made by Lieutenant General Sibiya in his letter to Lieutenant General Sintemule, dated 4 February 2025. That letter also makes clear that Lieutenant General Sibiya claims to be acting on the instruction of the Minister of Police to disband the task team. And that letter is also part of my file too. The affidavit, the post...
So can I just ask you maybe, before you move to paragraph 89, to go to VR5 at page 105 of Van Rooyen 2. Paragraphs 3 and 4, you'll see in paragraph 3, in this letter from Lieutenant General Sibiya, he says, on 31 December 2024, the Minister of Police issued a directive to the National Commissioner to immediately deactivate and disband the NTTPK. This decision was informed by an assessment that the task team no longer significantly contributed to policing efforts. And before I go to paragraph 4, perhaps that question that Commissioner Khumalo was asking about whether it's, was it a national task team? In other words, national character, but operating from KwaZulu-Natal. There's the N part of the...
That's correct.
The PKTT. The N there stands for national,
Yes.
correct?
In this regard, it will be the National Task Team on Political Killings.
Right. And then if you then proceed to paragraph 4, which is where I want to ask you the question. It says the directive requires immediate compliance with appropriate measures to be undertaken to ensure the effective disbandment of the task team, and the following words are the ones that I'd like you to focus on, in accordance with current prescripts in this regard. Can I ask you two questions here? Or one question that covers two aspects. Are there prescripts within SAPS that regulate the disbandment of task teams? That's being the one question. And are there prescripts that relate or that regulate the transferring of dockets? If you can just ask, so if you can just deal with them.
Chair, I'm not
Separately.
aware of any instructions, either national instructions, standing operating procedures, or circulars that deal with the transfer or that deals with the dealing of dockets when a task team is disbanded. There's no prescripts relating to that. There is a national instruction on case management, and specifically that addresses the transfer of dockets from a CAS station, CAS being the crime administration system. When a complaint is reported to the police, it is reported on our CAS system, as I indicated, crime administration system. It is opened, and for purposes of statistics, it is reported on the system. For example, if a case of murder is opened, it will be registered as a murder docket, and the CAS number will be allocated to that complaint. And that CAS number is important because it enables a complainant to follow up on the investigation. It's almost a reference number. And of course, that CAS number also, or the docket retains that CAS number when it goes to court, and even when that case is completed in court. When the docket comes back after court proceedings have been concluded, that case docket is finalized on the system with a link to that CAS number. So we have a national instruction dealing with CAS in that regard. And the only provision in that instruction where, in my mind, would have been the appropriate place to deal with the transferal of dockets regulates the transfer of dockets from a CAS station, in other words, a computerized station that has access to a computer, to a station where there's a manual system, and how that docket should be transferred. In other words, from a computerized station to a rural station that may not have a computerized system, or vice versa. If it is reported at a small rural station that doesn't have computer access and it needs to be transferred to a station that has CAS, that's the only instructions that I'm aware of, internal instructions dealing with transferal of dockets, which of course in this case it will not be relevant because we are talking about cases that were reported in KZN. And CAS numbers would have been allocated to them.
Thank you. Then in paragraph 89, you attach extracts of an affidavit that the National Commissioner filed in the litigation that he testified on, that had been instituted by Lieutenant General Sibia, and you attach that as annexure VR6 at pages 109 to 119. The only one point there to mention regarding that annexure is that some of us grew up aspiring to drive that car of a VR6. But other than that, there is no need to go into that annexure, because what that does, it outlines those engagements between the the National Commissioner and Lieutenant General Sibia, where he sets out the first approach on the 14th of January with that proposed letter, which the National Commissioner did not sign. It goes to the 15th as well, where Lieutenant General Sibia approached the National Commissioner again, And even at the conclusion of that meeting, that affidavit also sets it out that it had not been signed. Then you have, from that affidavit, Lieutenant General Khumalo and the National Commissioner briefing the Minister on the 16th of January 2025, and the following day, being the 17th, is when Lieutenant General Sibia decided to write that letter in his own name, which on both occasions when he approached the National Commissioner had refused to sign, and on the 15th he had said, leave this issue to me, I'll deal with it. That's really the import of what is contained in there, because you connect it later on in your statement. And if I can then ask you to deal with paragraph 91, this is after you say the evidence of the National Commissioner arising from that affidavit is that he worked with Lieutenant General Khumalo to prepare a report to the Minister on the alternative proposal to the disbandment, but that he never authorized the handing over of the dockets. Then if I can ask you to proceed from paragraph 91, concluding with 92.
However, Lieutenant General Mkhwanazi, as a Provincial Commissioner, confirmed that he was never informed prior to the removal of his dockets, nor was he consulted on the possible disbandment. From April 25 to August 25, these dockets were stored at head office in compliance with Lieutenant General Sibia's direction. In September 2025, a joint media statement was released by the Ministry of Police and the National Commissioner, directing that the dockets head back to KZN. And this is part of my File 2, VR7, a newspaper report confirming the terms of his statement.
Yes, that's at 118 to 119. The National Commissioner testified on that and gave context regarding that media statement and how it was misinterpreted, because that process had commenced long before the postponement of the commencement date of the commission, and he had explained that properly in his evidence. Then the next topic.
Mr. Mutau, before you go to the next topic. General, focusing on the prescripts, we know what General Masemola said and what General Mkhwanazi said. Is it consistent with any prescript that you are aware of, whether it's the national instructions or other directives? Is it consistent with any of those for dockets to be taken from a province or a unit or a task team and be stored at national office for a period of up to 5 months without any investigations taking place?
No, Commissioner, it is not. And I think the first reason that raises alarm is it means the investigations are stagnant. Nothing is happening. On that investigation, you would expect the police to proceed as fast as possible and make a breakthrough. But the longer the dockets remain unattended, the more difficult it becomes to investigate that cases properly. Evidence get lost, witnesses forget with time, and therefore the investigation, any investigation, will be detrimentally affected if it is stored somewhere and no attention it doesn't receive attention in the furtherance of the investigation.
Is that not, in your view, tantamount to the suppression of investigations?
It may very well be, yes.
And in paragraph 102 of your statement, page 35, you say this actually undermines the constitutional objects of SAPS as set out in section 2053, especially in respect of ongoing criminal investigations and the potential risk that further crimes may be committed.
Yes, sir. Yes. Especially if you consider evidence such as firearms. As long as the firearms are out there, they can be utilized to commit crime. So you would expect the police to act as soon as possible to take the firearms into custody to ensure that no additional offences or further offences may be committed in the unlawful possession of such firearms.
Just out of interest, what does the prescript, you mentioned earlier that there was either a national instruction or some other document that dealt with the movement of dockets. Maybe if you can just repeat that evidence, and just out of interest, what does it say? Is it relevant at all to the case that we are dealing with?
Commissioner, it deals specifically with the administration of cases or the administration of case dockets. And the principle is they must be...
Sorry, please identify that prescript again so that we have it on record and then give the answer you're about to give.
It's the National Instruction on Case Management. And it deals with, as I said, the whole process when a case is reported to the police and it receives a CAS number, which is basically a reference number, and how the docket is opened, and the procedural aspects, not the investigation, but the procedural aspects of the docket. And it deals with the transfer of dockets between CAS stations and non-CAS stations, and the principle there is there must be record keeping. In other words, when it leaves one office or one police station and it goes to another police station, there must be record to indicate who received it. On the other side, when it arrives there, who receives it and the date. So that the principle is really, if after 2 months or after a period of time somebody's looking for it, you need to have a paper trail to see what happened to it and who signed for it, so that we can locate the dockets, and that it's not, it doesn't disappear or is lost somewhere in transit or at a station where nobody knows it went to.
Thank you.
Thank you, Commissioners. Now we go to the substance. This is where you are now going to pull all of this together. Why these prescripts? Why these oversight mechanisms? After dealing with the disbandment, you're going to be dealing with whether there was a failure other than the Parliamentary Portfolio Committee on Policing, which did not do anything once it became aware of these allegations. And you are going to be discussing a question whether what happened here, which is on the version of General Sibia and General Masemola, if that evidence is accepted, is it an issue that relates to lack of oversight mechanisms or inadequacies of legislation, or you say it relates to something else? You start then by addressing the topic, is the disbandment a policy decision or is it operational in nature?
And when, Mr. Mota, when you refer to General Sibia, that is what he has said, you are referring to what we see from the annexures, yes, because we are yet to hear his evidence.
Yes.
Thank you. Thank you.
No, sorry, not General Sibia. I apologize. I'm talking General Mkhwanazi and General Masemola.
Just as well, I
thanks. Thank you, Chair.
Thank you.
I tried yesterday to say I'm not going to rename, but I see that the opening Bets Person's chalice of poison has cascaded down. General, if I can then ask you to deal with that topic commencing from paragraph 93, where you say from a regulatory standpoint, if I could ask you to take it from there.
From a regulatory standpoint, and based on the legislative excursus detailed above, I am of a view that the decision to disband the PKTT as a task team lay within the exclusive authority of a national commissioner, and that the minister did not have the legislative authority to disband the PKTT, let alone the manner in which he did. I say so for the following 6 reasons, one of which is in the alternative. Firstly, Section 206 of the Constitution enshrines the role of a minister primarily as that of providing policy direction at the national and provincial level. The Minister of Police is not a technocrat. His or her role is to advance the development of legislation and national police policy, particularly in respect of key issues that require executive attention. Therefore, a minister is empowered to select which areas warrant specialized intervention and attention, such as cash in transit, illegal mining, gangsterism, etc. However, a minister cannot prescribe or direct at an operational level, how policy is to be implemented. That is to be left to the National Commissioner, especially in view of the fact that this relates to the distribution and deployment of resources and has financial implications, which falls within the exclusive authority of a National Commissioner as the accounting officer of a Department of Police in terms of Section 36 of the Public Service Management Act. In the event that the Minister is of a view that a particular issue is no longer a priority and no longer warrants additional or specialized resources, the Minister is entitled to express that opinion or his position. However, its implementation falls within the exclusive remit of the National Commissioner.
And in fact, if I can just stop.
And what would the juristic nature of the expression of that position be?
I apologize, Chair. Can you just repeat the beginning?
You say that the minister is entitled to express that position. That is,
Yes.
if he's of a particular view that an issue is no longer a priority. So the minister is entitled to express that position. So my question is, what would the juristic nature of the expression of that position be?
Chair, for me, it's important that the Minister in his engagement, either as the Minister on political level or in his engagement with the communities, hear what they are saying. And if, for example, they say the gender-based violence is no longer a problem in our community. Let's hope that we ever get to that point in South Africa where we say it's no longer a problem. And the Minister then discusses with the National Commissioner that according to the community, gender-based violence is no longer a problem, therefore you don't need that additional resources. Then the National Commissioner can say, but Minister, do you know that gender-based violence is still a problem, and we've got statistics to support this or evidence to support that. So I don't think there's any topic that's off limit for discussion insofar as it relates to policing. However, the issue is the execution thereof and how it impacts on policing. That is the question where the responsibility or the involvement of a minister stops. And specifically to prevent political interference in the day-to-day operations of the police.
So the juristic nature would either be policy or direction.
That is correct.
Thank you.
No, thanks. I think the Chair anticipated the clarification that I sought or wanted to seek. So you can proceed from paragraph 98.
Secondly, the National Commissioner is called in terms of Section 207 of the Constitution to exercise control over and manage SAPS. The National Commissioner remains responsible for operational control and resource allocation or distribution. Again, where a minister identifies a priority area, the task of how to implement and what resources to deploy rests with the National Commissioner. In circumstances where the ministers say that a particular issue is no longer a priority issue, then it is within the remit of the National Commissioner to determine how best to operationalize that expression. Turning to the facts before this Commission, the Minister unlawfully strayed into the constitutional competence of a National Commissioner when he issued a letter for the disbandment of the PKTT. What would have been an appropriate path is for the Minister to express that he no longer considers political killings to be a priority and direct the National Commissioner to consider and take steps to align it with his directive. It can never be appropriate for a Minister to instruct the National Commissioner not only to disband the PKTT, but also to say that the disbandment must be done immediately. That constitutes not only an usurping of powers of a National Commissioner, but also undermines the constitutional objects of the SAPS as set out in Section 205(3), especially in respect of ongoing criminal investigations and the potential risk that further crimes may be committed. Thirdly, due to the nature of the offences under investigation, a task team like the PKTT is privy to politically sensitive materials, and its dockets would need to be treated with the same sensitivity. The dockets could not simply be taken back to their respective police stations and investigated in the normal course. I say this because politically related cases are highly organized and are executed through different role players, such as hitmen, spotters, coordinators, and persons who ordered the hits. In addition, they typically involved a conspiracy implicating well-resourced senior politicians and business persons.
Before you go on, you preface your firstly to, is it finally or lastly? Finally at 110. You preface those by saying that what the minister did not have a legislative basis or foundation. I read what you say under your thirdly, that is paragraphs 103 and 104, to address an issue of implementation and not so much a question of legislative entitlement. Do you get my point?
Yes.
So, which would therefore mean that 103 and 104 do not really fall under your preface.
Chair, it would relate more to the implications, but you are correct in your assessment. It does not deal with the fact that he didn't have legislative authority.
So as not to waste your time, let me make a similar point, and I will not ask you to comment. I take the same view with regard to your fifthly as well. That too does not relate to legislative authority or legislative entitlement or lack thereof. Just look at your fifthly. Do you agree?
Yes. Yes.
Thank you.
It does not refer to
Yes.
any power or role of a minister.
Yes. I interrupted you when you were to go to 105 under your thirdly.
Therefore,
Sorry, Chair, and I think perhaps to complete that line of references that you have given, 101 would equally fall there. In other words, no challenge to the competence to issue, but the implementation.
To exercise control over and manage substantial Maybe we would have to look closely at that, because I think secondly, under which 101 falls, does deal with a legal issue. And then what follows right up to just before thirdly is a substantiation, or is intended to be a substantiation of the legal issue, which is the secondly.
Thank you.
We will have to look closely at that, Mr. Mutale.
Thank you, Chair.
Thank you.
Yes, then please proceed from 105.
Therefore, the appropriateness of a directive to handle these dockets in such a manner when their contents stood to destabilize and potentially implicate senior politicians and established business persons should be determined by the Commission. Fourthly, the PKTT was created in collaboration. It has its genesis in President Ramaphosa's tasking of an interministerial committee comprising of the Ministers of Police, SSA, Defence and Military Veterans, Justice and Correctional Services to establish a multidisciplinary team to address the ongoing scourge of political killings in KZN. Thereafter, an integrated multidisciplinary task team consisting of members of the police, NPA, SSA, and correctional services was established with Lieutenant General Khumalo appointed as the project leader of this task team. In their evidence before the Commission, both the National Commissioner and Provincial Commissioner have testified that they were not consulted before the decision was taken by the Minister. In his evidence, Lieutenant General Mkhwanazi provided the Commission with a letter by the Director of Public Prosecutions, Advocate Harrison, where she queried if the PKTT still exists, again revealing a major stakeholder who was not consulted. Assuming that their evidence is accepted, it speaks to a lack of consultation of relevant stakeholders concerning the disbandment. Fifthly,
Before that, General, you're not just to be clear, you're not suggesting that there was an obligation, a legal obligation on the minister's part to consult with any of those stakeholders, are you? And I guess what I'm trying to check with you is whether you draw a distinction between a legal obligation, wherever that is sourced, and perhaps the wisdom, a comment about, and I'm sure there's a stronger word for what I want to say, but that it may have been unwise. You're showing why it was unwise, that the minister proceeded the way that it did. There's that distinction. Which one is it?
Commissioner, it may have been unwise. And the reason why I'm saying it, remember when it was established with consultation between the different departments. And therefore, I believe some of the departments may have felt we're still in it when the decision was taken to disband. So the difficulty is the implications even interdepartmentally. Some of the prosecutors may continue with the view that this is still a task team when in fact the decision was taken not to continue with the task team.
Yes, I think perhaps if we could just, while we are there, we know that you attached the letter by Advocate Harrison, which is VR8 at 120 to 124. And we're not going to deal, with that letter in detail, but part of what the prosecutor is asking is there are dedicated prosecutors who deal with these PKTT cases, and the confusion that arose from whether does it still exist, does it not, should they release the prosecutors? Because you'll recall part of the modus operandi was that people from outside the province were brought into KZN to deal with these cases to avoid or minimize interruption and interference and or infiltration. So that's in that context, as I understand the point that you are making in paragraph 108 and 109 regarding NPA as a stakeholder.
Yes, that is correct. I think the implications, because it's an interdepartmental task team, the implications will also affect the other departments, and they also had to be prepared on the reallocation of resources, whether it's personnel or other resources, to ensure that the affected or the decision as it was to be implemented is also implemented in their respective environments.
Then I think you can move to paragraph 110, where you make provision interpretationally for two scenarios, but in particular...
Sorry, Advocate Mutau, before you go there, General, I had understood you to be saying that because it was a multidisciplinary task team, it wasn't just a police task team, it was multidisciplinary, and it was established by various stakeholders. It was not competent for the Minister of Police on his own to simply disband it, because it affected entities such as SSA and NPA and the others that you have mentioned. That's how I had understood you.
That is correct.
That's,
Is that correct, though? And this is apart from the discussion about whether it's a policy decision, assuming he could make the decision, and the PKTT is what it is and constituted in the way that it was by an interministerial committee. If you say it wasn't competent for the minister, then we have to locate it in some instrument. Why we say that? As in, for example, it was in its foundation, was there an agreement or a contemplation that it will continue to exist until it is dissolved? Because it's quite a high mark that you're putting to it when you say it wasn't competent of the minister to do that, and I think we need to be certain about the legal basis for making such a statement.
Commissioner, as I understood it, the instruction or the directive came from the President in view of a priority of political killings in the province. An interministerial committee consisting of various ministers were informed of the instruction. They gave it through to the Director Generals of their departments to operationalize the instruction. The political task team was established in the police in view of the role of investigation, but they were allocated or assigned prosecutors to deal with that task team. So the task team itself was a police task team, but the resources or a broader implication was that there were specific prosecutors assigned to deal with cases that were investigated by the task team themselves. And therefore, my submission is, if a decision is taken on a political level that the task team no longer is justified, then that decision should at least have been discussed with the counterparts on the level of ministerial level. They could have agreed or they could have raised concerns, but for me the important thing is that should have been shared by the political role players, or if a minister took that decision with his counterparts, because it affected their departments as well. Keep in mind, as I said, the implementation and operationalization thereof was within the departments, but at least if a decision was taken on ministerial level, it should have been discussed with the other relevant ministers as well.
So what I'm trying to be clear about in how we speak about it is that accept that your evidence is there should have been discussion with the other role players, and I can see how one can fault that. But if we say it fell within the SAPS, this PKTT, it must mean, and correct me if I'm wrong, that and I think that's how I've understood you, that the National Commissioner could have made a decision to dissolve it. There was nothing that precluded him. And so that's where the decision or the power to make a decision, as I understand it, about its continued existence, it laid in the office of the National Commissioner. Am I correct with
Yes,
that?
that is my submission, Commissioner.
Thank you.
And the reason for that is it was established by the National Commissioner. So if a disbandment is to be done, it should come from that same functionary.
right. Perhaps let me just leave that topic with this comment. Evidence is that this is a national project that is operationalized in KZN through SAPS as a lead partner in the implementation of the project. I want to leave it at that. I don't want to take it beyond that, because there'll be a relevant point where submissions are made about the import of this and where does it sit and how should the relevant section of the Constitution be interpreted for purposes of the lawful exercise of this power, taking into account the conspectus of the entirety of the facts. I will not detain you on that issue of whether which is the correct interpretation for now. But in 1110, you make provision for an alternative argument. If I can ask you to proceed from 1110.
May we take an early lunch adjournment and resume at 2:15. May we adjourn at this stage. So no time will be lost. 1 hour still. Let's adjourn.
So you're saying I cannot? of your statement, and you were about to start dealing with paragraph 110 and 111 before moving to the next topic. If you could please just deal with those two paragraphs.
Finally, even if I am wrong on this score, and the decision of a minister to disband the task team can be said to be a policy direction, the direction that the disbandment be done so immediately strays into the operational remit of a national commissioner. Furthermore, even if one were to assume that the minister was empowered to disband the task team, the manner in which he did could not be lawful and resulted in operational confusion. On the one hand, Lieutenant General Sabia took certain steps to take transfer of the dockets while claiming to execute an order from the minister, whereas on the other hand, he circumvented the National Commissioner who was at the time taking steps to prevent the disbandment.
And in fact, just to locate that evidence in its proper context, given what you said earlier, by this bypassing, you're referring to that incident of the 14th and the 15th of January, where the engagement between Lieutenant General Sibia and the National Commissioner was concluded on the basis that the National Commissioner said to Lieutenant General Sibia, leave it to me, I'll deal with it, and he did not sign the letter.
That is correct.
And then on the 17th, after a day after the minister was briefed, Lieutenant General Sibia then decided to write that letter.
Or to sign the letter.
Well, sorry, yes, to sign it in his own name, despite having said despite the National Commissioner having said to him he should leave the issue.
That is correct, Mr. Madal.
And you say that brings in sharply, or rather sharply into the question whether could the Lieutenant General Sibia bypass the instructions of the National Commissioner on the justification that he was implementing the minister's directive?
No, the decision to sign that letter circumvented the clear instruction of a National Commissioner.
Before you go to the next section, just out of interest, General, when did legal services first become aware of the letter of 31 December 2024?
Commissioner, I can only speak for myself, and it wasn't in January. I heard rumors that a letter was leaked, but as a good lawyer, I don't pay any attention to rumors. I want to see hard evidence. So as far as I recall, I wasn't aware of that letter in January. For the rest of my colleagues, I cannot testify to their knowledge.
And as far as you know, was there ever an internal discussion about the lawfulness or otherwise of that instruction?
Not
I know
that
there
I
was
was
nothing formal because General Masemula said
Yes.
he did not obtain a legal opinion.
Not
But
that
just
I
out
was
of
part
interest,
of.
Are you aware if there was ever any internal discussion from
Not
the
that I
lawyers?
was part
Because-
of.
Yeah.
Yes, not that I was part of, Commissioner.
Thank you, Commissioner Kumalo. Then your next section is headed General Observations on Legal Aspects Raised. If I can ask you to then take it from paragraph 112 and following.
Chair, the purpose of this is, I've been here for a couple of days and I've also made notes on some aspects that were raised by yourself and by the commissioners on legal aspects. And I appreciate, and I believe you will also appreciate, that the two previous witnesses were not people with any legal background. And therefore, I believe it may be to the benefit of a commission to at least clarify some aspects in as far as I can to assist the commission. In furtherance of some of the issues raised by the commission, I wish to point out certain aspects to assist the commission. Firstly, the letter of the minister dated 31 December 2024 also directed that the filling of vacant posts in the Division Crime Intelligence, both at provincial and national level, should be halted immediately. No explanation was provided for that direction by the Minister.
Perhaps if I could just, for record purposes, that's VR1 in Van Rooyen 2 at page 102, paragraph 1.
That is correct.
Okay, yes. Yes, if you can proceed.
Section 27 of the SAPS Act provides that the filling of any post in the service, whether by appointment, promotion or transfer, should be done in accordance with this Act, which also includes the SAPS employment regulations. Section 28 furthermore provides that the National Commissioner may appoint a person to a post in the fixed establishment of a service. Regulation 27 of the SAPS employment regulations provides that the National Commissioner must inter alia, before filling any vacancy, confirm that he or she requires the post to meet the objectives of a service and ensure that that sufficient budgetary funds are available for the filling of a post. The involvement of a minister in respect of a filling of posts are limited to senior management services members, that is, employees appointed to a post-level grade on 13, in other words, brigadier and above. Insofar as the National Commissioner is, in terms of Regulation 27, required to report to the Minister on this information and to obtain any directions that the Minister may issue. There is, however, no provision in the SAPS Act or employment regulations that authorizes the Minister to blanketly halt the filling of posts in a particular division of a service or even in the service as a whole. It is my considered view that the Minister's conduct constituted executive overreach.
Right. After that conclusion on that paragraph 1 of the Minister's letter, you proceed with your second point in paragraph 116. If I can ask you to proceed from there.
During the testimony of a National Commissioner, an issue was raised on the possibility of approaching court to resolve the impasse with the Minister. Assuming that this evidence is accepted, it should be noted that there is a principle that the state does not litigate against itself. In other words, the executive and head of department should not resolve differences or disputes in court. And the reason for this is the state attorney is responsible for litigation on behalf of the state. So the state attorney will act for both the executive and the head of department, which brings a conflict of interest. It is in part, this is also in part necessitated.
That can be a very serious stumbling block, because I've seen in such instances the state attorney using private attorneys or the client itself, whether it's a client department, going to private attorneys itself. So that's not really an impediment.
There's exceptions, but the exceptions are meant to be not the general rule or really exceptional circumstances that necessitates this, but this shouldn't be a matter that's considered lightly. Not in view of the seriousness of the dispute, but in view of the seriousness of the consequences of litigation.
Yeah, I'm just mentioning it because, for example, the example you give would be exceptional circumstances, I would have thought. Yeah.
General, isn't the issue this, that the Commissioner could have obtained legal advice, and if that advice said the instruction is unlawful, then he could have said to the Minister, Minister, we will not implement your instruction because it is unlawful.
That is correct, Commissioner. He could have sought legal advice, not going to court. But the issue I'm addressing is specifically, I remember there was a question on the possibility of litigation. But I agree with your approach. Legal advice should have been sought to get clarity on the legal position.
Yes, and perhaps if I could just come in there, the National Commissioner, when dealing with that issue, he gave his reasons why, for him, taking on his own minister was not an option. And I think the Commission will have regard to his evidence, because he did deal with that issue. And if I can ask you perhaps to deal with 117, where you start with Chapter 3 of the Constitution.
Chapter 3 of the Constitution.
Sorry, General, before,
Sorry,
before
apologies, Commissioner.
yeah, before you do that, and do pardon me for taking you back to paragraph 115, your conclusion that the minister could not blanketly halt the filling of posts. This is something that I guess one should have explored with the National Commissioner, but now that you speak to it, let me check this. We didn't get to see the advert for these crime intelligence positions, so we don't know whether they were advertising for positions where the minister is required to be consulted. I think you said in consultation, and then there's a level where it's the National Commissioner's decision. Are you able to say what positions those were?
I have no knowledge of that, Commissioner. However, what is concerning is there's no differentiation or qualification of a filling of post. So I would assume that it cuts across different levels. It didn't even say only the filling of senior managers. So there should be posts available on different levels, including junior levels, medium managers, and senior levels.
And to your knowledge, do ministers or Minister of Police become interested in the advert? The evidence that we had was the minister picked up something about the advert, said it initially advertised for a diploma or a degree, and then he had views about it should be changed. Is that something that ministers become involved with?
Not in my experience, Commissioner. In fact, it's more of a pro forma advertisement that we have when posts, for example, becomes available or are to be filled in legal services. There's almost a pro forma requirement of certain requirements pertaining especially to qualifications. And you would expect, for example, a media manager to have a certain number of years experience and a certain qualification. So it is not something that the minister would get involved in or play any role in. On that regard, if I can also clarify, earlier this morning we discussed the issue of Regulation 47 of the employment regulations that specifically deals with the involvement of a minister in the appointment of senior selected SMS posts. And as I indicated, it relates to generals posts, in other words, major generals and lieutenant generals, excluding provincial commissioners, but including divisional commissioners and deputy national commissioners. And the difficulty with that is that the selection panel and the actual appointment must be done in consultation with the minister. So that also is problematic because it means that the minister's agreement in the appointment of any general, excluding provincial commissioners, are sought. And that is also a matter for consideration, the implications of that.
Thank you, Commissioner Bala. Earlier on, I referred to the National Commissioner's evidence regarding Lieutenant General Sibia's 3 areas of contentions. If you recall, I touched on that issue where there was an expression of certain of the dockets in crime intelligence being moved into his portfolio, you remember? Then I also said National Commissioner testified that even when the minister took office, he expressed the 3 identical points that General Sibia had identified earlier, you recall? And I had left this issue, didn't deal with it, as the second issue that relates to crime intelligence, where the minister directs a halt. But I think let's leave that, and perhaps the minister will explain.
Yes. Yes.
his interest in crime intelligence. If I can then ask you to proceed to 116. Secondly, sorry, is that where we were? Sorry, no, sorry, I apologize.
Yes.
We had dealt with 116. You were going to 117, chapter 3. Yes.
Mr. Madau, I was in part busy with 116.
Okay.
And the point I still want to make there is pertaining to the issue of litigation between the executive authority and the head of department, and also to indicate that another factor to consideration in an attempt to avoid litigation is that this is in part necessitated by the fact that public funds will be utilized to litigate, and an accounting officer is required in accordance with Section 39 of the PFMA to ensure that expenditure of his department is in accordance with the vote of the department and the main divisions within the vote, and that effective and appropriate steps are to be taken to prevent unauthorized expenditure. And you can never budget for litigation. In the police, we are well aware of that, especially in view of a contingency liability of civil claims. So it's not something that you can budget for.
Okay. All right, I think your point is taken. Paragraph 117, chapter 3 of the Constitution.
Chapter 3 of the Constitution furthermore emphasizes the need for cooperative government and the need for all spheres of government and organs of state to cooperate. Surely these principles can also be expected to be complied with within a department itself, and not only to regulate relationships that exist with other departments or other spheres of government. This matter is even more critical within the security cluster, where sensitive matters are discussed and shared, and where the potential disclosure of intricacies of disputes may negatively affect safety and security of a country. Thirdly, the terms of reference of a commission provides for the consideration of the effectiveness or failure of oversight mechanisms. In my view, the commission, and not the committee,
Should be the commission.
should consider this aspect continuously in the evaluation of evidence presented. However, in my view, the question should also be posed whether oversight could or would have made a difference in some of the matters. For example, the Commission has been presented evidence about the conduct of Lieutenant General Sabia relating to a letter presented to the National Commissioner to formalize the disbandment of a task team. Assuming this evidence is accepted, the conduct of Lieutenant General Sabia to repeatedly approach the National Commissioner with the same letter on subsequent dates and thereafter signing the letter without authority, while he was fully aware of the instructions of a National Commissioner, is not a matter that could be dealt with by means of oversight or more effective oversight.
Please remind me of the repeatedly. I thought General Sabia met the National Commissioner. The National Commissioner said, I will attend to the matter, forget about your letter, and then General Sabia signed the letter himself. Just remind me of the repeatedly.
It was 2 consecutive days, Chairperson. I believe is it 14 and 15?
My co-commissioner, Commissioner Kumalo, has a better memory than I am, but of course I'm sure age accounts for that.
Commissioner Kumalo, I appreciate your assistance.
Yes, yes, it was 14 and 15. You're quite correct. Thank you, Chair. Yes, and you say according to you, you were dealing with that issue. It is not a matter that could be dealt with by means of oversight or more effective oversight. Perhaps you can finish that part and then.
Let me just find it.
Yes. According to
the testimony of a National Commissioner, his instructions were ignored by a Deputy National Commissioner.
I think he also says that in the affidavit,
yes,
in the High Court application.
Yes, and I think in this regard it may be important to note that oversight is really outside the organization. In this case, the issue related to internal disregard of instructions, and especially in view of a chain of command in an organization such as the police, and the compliance of an instruction is critical to ensure that policing operations and command structures are respected. So I cannot disregard an instruction of my commander. It simply doesn't work that way in the police for good reason. And I realize, Chairperson, there's going to be exceptions, but I believe you will understand and appreciate the point as a general rule that I am making.
So can I just ask you, just to clarify that point a bit, you say oversight is external. In other words, it is looking outward, as opposed to oversight that looks at the internal mechanisms.
There are internal mechanisms, for example, the discipline regulations, and that will be the appropriate manner to deal with subordination. But I think the focus has been so far, especially in the discussion on the oversight bodies, for example, the Portfolio Committee on Police, even the other departments within the ministry, their involvement in this matter this matter falls outside that issue of an instruction of a junior, in this case the Deputy National Commissioner, disregarding the instruction of his commander. And in that regard, oversight and the possibility of strengthening oversight should be carefully considered in view of the fact that it's not a normal process. And for example, by extending additional powers to a Chapter 9 institution, you cannot prevent this occurrence, or it couldn't have been foreseen to have prevent such an incident.
So in other words, this issue that the Commission is dealing with here at the level of facts, and assuming that evidence is accepted, it is not an indication of lack of oversight or even legislative inadequacies. Because you say in terms of the chain of command and the ordinary rules of employment, it was not to be expected that after the National Commissioner had instructed the Deputy National Commissioner to leave the issue with him, that the Deputy National Commissioner would go ahead and issue that letter in his own name, which we know from the evidence that the National Commissioner gave that he only found out about that letter much later. And that's the point you're making. It's not an oversight issue or lack of oversight or legislative inadequacies, but it is, as you say, something that happened internally that could not have been anticipated.
That is correct, Mr. Madau, yes.
So, no, sorry, I forgot to say, when I ask a question, you always respond to the chair. So the question, although it comes from me, the answer is always to the chair.
I hope this is the last time I need to apologize for today.
No, sorry, it's my fault. I didn't clear that with you. In fact, that point about the National Commissioner only becoming aware of the existence of the letter signed by the Deputy National Commissioner much later, you say it cannot be overlooked. This is in paragraph 120. It points to the disregarding of an instruction of a commander, in this case, the National Commissioner.
That is correct.
Okay. If you can then proceed from 121.
In addition, the National Commissioner testified that he had doubts, though he did not express them, on the lawfulness of the instruction of a minister on the disbandment of or the establishment of a PKTT, but elected to facilitate and oversee the winding down thereof on his terms, for reasons explained in his testimony. The nature of an organization such as the police requires a clear chain of command and requires respect for instructions and directives. The National Commissioner had no reason to doubt the bona fides of a minister at the time of the direction or directive, or to second-guess the motives of a minister. The apparent motives for the directive only became evident later.
Yes,
The
please,
reasonableness of the conduct of a national commissioner in this regard ought to be considered within the context of the circumstances at the time, and as he indicated, he was surprised by the directive and the lack of explanation for the decision. However, the difficulties that flowed from the minister's directive cannot be attributed to a lack or failure of oversight mechanisms. It is attributable to factors that came to light much later and on account of discoveries from the ongoing investigation testified to by the National Commissioner. These discoveries point to both the minister's and General Sibiya's conduct. In this regard, the National Commissioner testified at paragraph 182.2.
So 184?
184.2, subsequent phone records obtained from an attempted murder accused revealed communications implicating Lieutenant General Sibiya in the forceful and immediate implementation of the Minister's directive to disband the PKTT. These records suggested that Sibiya's actions were not merely procedural, but rather tied to deeper connections with individuals identified as members of a criminal cartel. The timing and urgency of his compliance appeared to align with imperatives to shield cartel members from ongoing investigations. This is the subject of an ongoing criminal investigation. Then the National Commissioner also at paragraph 188 stated, in respect of the Minister, knowing what I know now, what I've considered to be irrational and inexplicable encroachment upon operational issues is now explained by his desire to hold investigations against criminal cartels by disbanding the PKTT. By this I mean the evidence that has emerged with links the Minister to Brown Mkhotsi, Kat Matlala and Lieutenant General Sibiya.
And if I can just pause there and qualify it the same way that you did when you refer to evidence that has been placed before this commission. It is obviously early days at the commission, and the commission will still hear more evidence. And this is all predicated on this evidence being accepted. And you say, if after hearing evidence of the Minister and Lieutenant General Sibiya and all other relevant witnesses, and this evidence is found to be undisputed or to be accepted by the commission, the point you are making is both the conduct of Lieutenant General Sibiya and that of the Minister, and again I qualify it, if so found, does not point to and or is not attributable to the lack of oversight mechanisms or the shortcomings in the legislative scheme that you touched on earlier. In essence, that's the point that you are making. Am I correct?
That is correct, Commissioner. Chair.
Yes.
That is correct.
And this does not detract from the other legislative amendments, or at least the reforms. Perhaps let me just take one step back. This does not detract from the later point that you make, where you identify certain legislative gaps or certain oversight mechanisms which you deal with on a preliminary basis. And you make it clear in your affidavit that SAPS intends at a later stage to make comprehensive submissions to the Commission for its considerations when it makes recommendations in respect of the proposed methods by which oversight mechanisms can be strengthened and the various legislation that you've identified. Am I correct?
That is correct, Chair.
Okay. Then proceeding in paragraph 123, may I ask you to take it from there? Finally,
I wish to provide some clarification in respect of the role of a Chief of Staff within a ministry. This role is regulated by Chapter 3 of a Guide for Members of the Executive, also referred to as the Ministerial Handbook, which deals with the appointment of certain staff in the office of a minister, including the appointment of a Chief of Staff, a Private Secretary, and a Media Liaison Officer as part of the office of the Minister of Police. The Ministerial Handbook, Chair, I thought I was done with apologizing, but I am apologizing again. The words that a Chief of Staff in that paragraph should be deleted. The Ministerial Handbook provides administrative and support assistance to the Minister in ensuring good governance with due regard to cost effectiveness and efficiency. In other words, that's one of the aspects and aims of a Ministerial Handbook, to provide clarity on the administrative support and assistance that the Minister is entitled to. And it should also be noted that appointments of personnel in the office of the Minister, in this case the Minister of Police, are regulated in terms of the Public Service Act. The duties of the Chief of Staff include to ensure that administrative support is rendered to the Minister in respect of parliamentary services, including to coordinate parliamentary questions, to perform administrative functions within the office of a Minister, such as internal and external role players with regard to the portfolio of a Minister, and to manage the office of a Minister effectively. This relates to the management of human resources and the budget of the office. In other words, these are the general powers or responsibilities to be performed by a Chief of Staff. The Chief of Staff may participate in discussions with the Minister and the management of the police. And in my experience, it really depends from Minister to Minister. In some cases, the Minister is, or the Chief of Staff is more involved in discussions and with the Minister and management, and in respect of other ministers, the Chief of Staff will be more in the background dealing with administrative matters. However, it should be noted that the Chief of Staff does not have any powers relating to the execution of policing functions. In terms of Section 207, the National Commissioner is responsible to manage and control the SAPS and remains accountable for the decisions taken by the SAPS.
And I think in this regard, the National Commissioner, when asked regarding the participation of the Chief of Staff in respect of decision-making, in respect of that plan, he indicated that when it comes to accountability, he, the National Commissioner, is ultimately accountable. And this makes it clear, I think, if one looks at the 2 points that you make. The first being that the Chief of Staff is appointed, or the appointment of the Chief of Staff is regulated by the Public Service Act, which you make at the end of paragraph 123. And then in respect of 125, you say the Chief of Staff does not have powers relating to the execution of policing functions. So those 2 read together makes that point explicitly clear. Do you agree?
That is correct, Chair.
Can
And then in terms of sex...
Can I just to clarify, General, you had the evidence of General Masemula that the Chief of Staff was advocating together with General Sibia for the immediate disbandment of the PKTT. Now, you accept from your evidence, you accept that, or at least you tell us that, Chief of Staff can participate or do participate in discussion between management and the Minister. Does that go as far as this kind of evidence where General Masemula says he was advocating for the immediate disbandment? Does the involvement of the Chief of Staff contemplate that kind of involvement?
Commissioner, in my experience, the Chief of Staff will be part of a meeting. He may say something, but I haven't had experience where such a strong opinion has been expressed in respect of any policing matter relating or coming from the Chief of Staff. That is not in my experience the position.
Thank you, Commissioner. Then you were done, you just concluded with 125, and you're dealing now in the next section with the deficiencies that you've identified. And I, again, just remind the commissioners that you had indicated that for now, as you stipulate in 126, you make these observations on a preliminary basis, so that the commissioners can take them into account as they hear testimony from different witnesses, and perhaps they may wish to test some of these issues with whichever relevant witnesses that would still come to give evidence. But as indicated earlier, a more comprehensive submission is going to be made by SAPS at a later stage. Is that correct?
That is correct, Chair.
Okay. Then in your endeavor to assist, you say in paragraph 127, you seek to highlight certain deficiencies in the statutory scheme and flaws in implementing the oversight mechanisms. And you start with the civilian secretariat. If I can ask you to comment from paragraph 1 to 8.
In terms of Section 6.1 of a Civilian Secretariat for the Police Service Act, the Civilian Secretariat is mandated to monitor and evaluate the performance of the police by regularly assessing whether SAPS have adequate policies and effective systems in place, and furthermore to recommend corrective measures where necessary. The Civilian Secretariat is further required to advise and support the Minister of Police in the exercise of his or her statutory powers and functions, and to report to the Minister on SAPS's performance, as well as its implementation of and compliance with policy directives or instructions issued by the Minister. By constitutional design, the Civilian Secretariat functions under the direction of a Minister, and that is set out in Section 208. The current legal framework does not permit the Civilian Secretariat to operate independently, even though it is expected to maintain an independent character in exercising oversight. Its effectiveness, therefore, rides on the Minister's strength, credibility, and willingness to respect the policy or operational divide. Its authority depends on political rather than statute-backed autonomy. Oversight facilitates with cabinet reshuffles. Sorry?
So oversight vacillates?
Vacillates, with cabinet reshuffles and ministerial preferences. And if I can make a very basic example, the Minister of Police is responsible for the police and the same minister to oversee the police. Now, if the two departments are at loggerhead, it means the minister must decide which of his children is correct. And that is a very dangerous position. There should rather be independence to ensure that it is a more neutral or objective decision to be taken.
So the essence there of the point that you are making is, on a forward-looking basis, some form of disentanglement that allows for independence is something that you say ought to be considered by the Commission as it navigates the issues and hears evidence.
That is correct, Chair.
Okay. You then next deal with IPID, commencing from page 43, paragraph 130.
Section 2066 of the Constitution provides that, upon receipt of a complaint lodged by a provincial executive, an independent police complaints body established by national legislation must investigate any alleged misconduct or criminal offence committed by a member of the police in that province. This gives effect to the constitutional in order to give effect to this constitutional requirement, IPID was established under the Independent Police Investigative Directorate Act. As I alluded to earlier, Chair, 2011 Act, not the 2010 Act. Section 2 of the IPID Act mandates the Directorate to ensure independent oversight of SAPS and municipal police services, to conduct independent and impartial investigations into specified criminal offences allegedly committed by their members, and to make disciplinary recommendations arising from its investigations. as well as to ensure accountability and transparency within SAPS and municipal police services in line with the principles of a constitution. According to the parliamentary media statement of Thursday, 19 June 2025, IPID is facing a severe case backlog of 14,469 cases carried over into the new financial year. This backlog has been flagged as a major impediment to police accountability, as it contributes to a lack of timely consequences for misconduct within SAPS. The delay in finalizing investigations undermined the ability of IPID to enforce disciplinary or legal action against offending officers, thereby weakening oversight and eroding public trust in law enforcement institutions.
Okay.
This statement further stresses that this situation is not merely administrative, but poses a systemic challenge to the criminal justice and oversight framework. Prolonged investigations risk evidence degradation, prolong justice for victims, and create space for impunity within SAPS. Parliament has therefore called for urgent strategies and interventions to resolve a backlog and strengthen IPID's capacity, signalling recognition for that current resources, processes, and case management systems are inadequate to meet its constitutional mandate. In respect of the mandate of IPID, I wish to point out that the Independent Police Investigative Directorate Amendment Act of 2024 amended the mandate of IPID to investigate, specifically the mandate to investigate matters as set out in Section 28 of the Principal Act. Some of the provisions of this Amendment Act came into operation on the 29th of August this year, but the amendment pertaining to Section 28 is still awaiting proclamation by the President and is dependent on the finalization of regulations. The implications of the amended Section 28 are that the mandate of IPID to investigate matters against members of SAPS and municipal police services has been expanded. The mandate will no longer include complaints relating to the discharge of an official firearm or common assault. The mandate will be extended to investigate cases of attempted murder in relation to the discharge of a firearm or the use of any weapon or instrument, and assault with the intention to cause grievous bodily harm, as well as torture, as defined in the Prevention and Combating of Torture of Persons Act. IPID is also in compliance with or as mandated by the Amendment Act, is also authorized to investigate allegations of a commission of an offence where a member, in other words, a member of a police or municipal police service, acted together with other law enforcement officers or members of the public.
Yes, and then you conclude there by saying, or dealing with the impact of the extension of this mandate on the already overloaded work of IPID. If you can then conclude.
The implications of the amendments will place an additional burden on IPID and will require additional resources, including investigators, to execute this mandate effectively.
Then the last topic that you deal with there is the portfolio committee and the identified shortcomings within the oversight structures of police. If you can deal with paragraphs 136 and 137.
The Portfolio Committee has identified shortcomings in relation to the oversight mechanisms within the police. According to a press release dated Wednesday, 12 February 2025, with the title Management Deficiencies from Station Level to National at the Heart of Repeat Audit Findings within SAPS. This Portfolio Committee on Police identified several shortcomings in the SAPS's oversight and management mechanisms. Key issues include repeated audit findings that point to station-level management failures, which persist across regions and are not properly addressed or corrected.
And if I can just perhaps come in, this shortcoming that you've identified here relates to financial issues and aspects of financial accountability.
That is correct,
Correct.
Chair.
You have dealt with the issue of the portfolio committee not acting on or responding to the allegations when they were brought to their attention when Lieutenant General Mkhwanazi was appearing before the portfolio committee.
That is correct,
yeah.
Chair.
And then you conclude then by attaching the statement to which you speak in respect of paragraph 137, and that is annexure VR9, which is at 180 to 188 of Van Rooyen 2, correct?
That is correct, Chair.
And you then conclude by saying, should it become necessary, you will prepare and submit a further statement should the Commission so require. And we've indicated earlier, this is apart from the submissions that you are going to make together with SAPS to address this topic, this last topic that you are dealing with, correct?
That is correct, Chair.
Now, you've given your evidence. You received different questions, both from myself and the commissioners. I just want to ask, from your side, is there anything that you wish to perhaps bring across to the knowledge of the Commission, which perhaps you could not, by way of a question that did not present itself?
Chair, there's just one comment I would like to make, and I realize we interrogated this aspect and the difference between policy on the one hand side and direction or directives on the other. And in my opinion, it's neither here or there. What is important is the potential political interference that comes with either the policy or a directive. So it is my submission, if I may guide the Commission, not to focus so much on the issue of whether it's a policy or a direction or a directive, but rather on the legal aspects pertaining to the implications of political interference, and specifically relating to where does the role of a minister stop and where does the role of a national commissioner starts. And in that regard, to bring clarity, as I said earlier, not only for the National Commissioner and the Minister, but even for the organization as a whole, to ensure that there's clarity on the role of each role player and specifically the danger and the risk to address the minimizing of the risk of potential interference. I realize we are talking about specific role players, but the organization will outlive the current role players and there will be new faces. And in that regard, the principles that must be set must be clear for future purposes and to ensure that the organization can withstand potential similar situations in future. As I also indicated, and I think I largely dealt with this matter, is if we consider the issue of oversight bodies, it should be noted that a number of problems that persisted or that originated in the police, albeit the conduct of a deputy national commissioner or even the interference of a minister, were internal issues. And in that regard, if consideration is to be given, I find it difficult to think that oversight bodies, especially external oversight bodies, will be able to address such situations. In a well-disciplined organization, it shouldn't happen. That is as simple as that. And even legislative amendments will not necessarily address the problems experienced in that regard. And therefore, I wish to make the Commission aware of that possibility of just considering my submission in that regard. Thank you, Chair.
So
Just,
in short, General, I think the point you're putting across is this, and correct me if I'm wrong. On the facts that the Commission is dealing with. The issue whether the Minister's communication on 31 December 2024 constitutes a policy or constitutes direction, you say whatever that is found to be by the Commission, it does not resolve the issue. The issue here is one of a factual nature, which is, regardless of the character of the instruction, it is the question of what that instruction contemplated or directed, or rather instructed, let me use a neutral term, instructed the National Commissioner to do. And you say that is the issue that strays into the exclusive domain of the National Commissioner, and that is why we are here.
That is correct, Chair.
Perhaps I should
Thanks.
clarify why we engaged you and General Masemula on what policy, directions, and operational matters mean. We engaged you on those because we can only really be able to say this is an operational matter and not a direction if we know what a direction is. Do you follow me? So
I
that
do,
is
Chair.
why we wanted to know what on earth is a direction. I think policy perhaps is easier to grapple with. But this is an operational matter. It's definitely not a direction. How do we say that? We must know what a direction is. So that's why we engaged you on those. But you are done with your testimony now. These are legal questions, and I guess it will be for us in the end. And after having heard Minister Mkhunu, what exactly juristically this letter of 31 December 2024 was. It will be up to us to decide. I hope you follow why we engaged you on the subject.
Definitely.
Yeah.
Thank you,
I
Chair.
understand your alternative, that even assuming that it was a policy, even assuming that it was a direction, but it impacted on operational matters, which is your alternative argument,
Yes.
which was also General Masemula's alternative argument. I understand that. But of course, we will have to hear Minister Mkhunu on that ultimately.
Can I just clarify something? General, just so that your evidence on the deficiencies, under the topic of deficiencies identified, so that it is understood or not misunderstood, you listed there the CSPS, the IPID, and then the Parliamentary Portfolio Committee. You're not saying that any of those deficiencies or those issues that you've identified as deficiencies, they have a bearing on what happened, on the facts that we are concerned with. You're not suggesting that.
No, I'm not.
Okay.
Thank you, Commissioner.
Thank you. Thank you, Chair.
Thank you very much, General, and thank you very much to the evidence leaders.
Yeah. No, Chair,
think we've
my
reached-
conclusion was going to be, we put a pause.
Yes. Let us adjourn and resume at 9:30 as usual. Yes, tomorrow. Let's adjourn.